Bom dia a todos, sejam bem-vindos. Hoje prosseguimos o nosso evento com o tema o Estado de Direito nos sistemas regionais econômicos e de direitos humanos. Convidamos, então, para a mesa a doutora Kalin Como Rodrigues, conselheira da OAB, que será a presidente da mesa no início dos trabalhos. Convidamos também o nosso ilustre palestrante, professor Heuschling, para compor a mesa. Convidamos também o Francisco Matos Folgado. O Francisco acompanha o professor Luque, também é da Universidade de Luxemburgo, e acompanhará o nosso evento hoje. Queremos dizer que é uma honra muito grande termos novamente, na sequência do nosso curso, a presença do nosso querido professor Heuschling, que ontem nos abrilhantou com a sua exposição, e hoje temos certeza que teremos o prosseguimento brilhante da mesma maneira.
Depois vem
Vou chamar também a presença do professor Carlos Eduardo Dieder Reverbel, que é o coordenador também do evento, professor da Universidade Federal do Rio Grande do Sul, da Faculdade de Direito. Sejam todos bem-vindos. Passo, então, a palavra para a doutora Kalin.
Bom dia a todas e a todos. É um prazer ter aqui novamente. Hoje nós estamos dando início ao segundo dia do ciclo de eventos Direito do Estado de Direito, com o professor Luque. Vou falar Luque, assim fica mais fácil. O sobrenome. E agradecemos ao pessoal que está em casa, acompanhando conosco. Para nós da UAB é uma honra tê-los aqui, principalmente, professor. É uma honra para nós, como o professor Gerson já falou ontem, a Escola Superior de Advocacia se sente honrada e satisfeita por lhe ter aqui, trazendo um pouco do direito constitucional, administrativo e da sua experiência, para agregar nos nossos 40 anos de ESA, para nós é muito importante. Nosso presidente da OAB também, Leonardo Lamac, manda um abraço para todas e todos. Infelizmente, hoje não pode estar aqui, mas amanhã vai estar conosco no encerramento. Então, hoje a gente vai dar sequência, nós temos painel A Chefia de Estado no Sistema Regional Econômico e de Direitos Humanos, com os palestrantes a professora Anair Schaefer, doutor Luque, e debatedor, doutor Alexandre Soares da Silva. Isso, desculpe eu falar, e o professor Reverbel vai substituí-lo hoje. Isso. Na sequência, eu vou ter que me retirar em função de outro compromisso, mas o futuro professor Francisco, que é português, diretamente de Lisboa, mas já há muito tempo em Luxemburgo, vai também trazer um pouco da experiência dele, tanto em função de Portugal, como falando um pouco também da experiência em Luxemburgo. Então, vai ser uma mesa extremamente enriquecedora. Infelizmente, não vou poder participar, mas quero chamar a professora Nair, que palestrará também, para me substituir aqui na mesa.
Bom dia a todos. Então, estou muito honrada de participar também à mesa com o professor Luque, que é uma grande honra de termos conseguido que ele tenha vindo nos visitar e nos abrilhantar com a sua experiência e o seu trabalho maravilhoso nesse tema tão interessante que é o Estado de Direito. Coube a mim, então, falar sobre o sistema americano
de direitos humanos. E onde que podemos dizer que esse tema se encaixa na chefia de Estado? Vemos que é muito importante, que a chefia do Estado também se conecta com os sistemas regionais de proteção e com os sistemas regionais econômicos e de direitos humanos. A esse lado. Certinho? Eu quero. Só um minuto, vamos organizar aqui a exposição. Pretendo, então, fazer a exposição de uma forma resumida, pelo tempo que me cabe, de demonstrar como que isso impacta na questão do no sistema interamericano de direitos humanos, com a questão do Estado de Direito em diversas formas que nós temos no sistema americano com a OEA. Tal como no sistema europeu, que o professor nos trouxe ontem alguns exemplos de países do sistema europeu, também aqui no sistema americano, nós veremos que os países se integram, então, à OEA e, a partir dali, fazem, então, a sua inserção no sistema interamericano de direitos humanos. O que é esse sistema interamericano, então? Ele é formado por o conjunto de tratados que trazem, então, toda essa proteção de direitos humanos para as pessoas. A intenção, então, é mostrar como o presidencialismo que nós temos na maioria dos países, de 20 países, né? Depois veremos, como isso impacta, como isso pode trazer um problema na chefia de Estado para os direitos humanos. E trazemos também, então, primeiro o desenho, depois a questão do presidencialismo, que é a maioria, e também, posteriormente, como é que, então, a jurisprudência da Corte Interamericana tem atuado nessa situação em que os países são, digamos, estão no sistema americano e estão ou não submetidos à Corte. E faremos, então, essa distinção rapidamente. Aqui eu queria trazer a questão que a gente viu ontem um pouco, que é esta herança. Quais são os países que, quando nós estudamos, em geral, nas faculdades, poucos são as questões que se verifica quanto aos países se são presidencialistas ou monarquistas. Não se olha muito isso, simplesmente se verifica nos estudos quem são os países que aderiram ou não. E nesse evento se pode justamente demonstrar a importância de olhar quem é a chefia de Estado e como isso se repercute, então, nas sentenças da Corte Interamericana ou mesmo nas opiniões consultivas. Eu trouxe aqui, eu só volto aqui um pouquinho, nós vamos ver que no sistema americano nós temos 2 órgãos institucionais importantes que fazem esse contexto, que é a Comissão de Direitos Humanos e a Corte de Direitos Humanos. A comissão, ela é o órgão que faz o controle, digamos assim, a análise anual de como está a situação de cada um dos países e da orientação. É a porta de entrada para que a vítima ou demandante, tanto a pessoa física como o Estado, que são os que podem demandar, ou mesmo organizações internacionais, podem demandar, ela é o primeiro caminho, ela é a porta de entrada, porque diferentemente da União Europeia, do sistema que congregou a função da Comissão e da Corte, se uniu após o protocolo 11 da Convenção Europeia, e lá toda a entrada é direto pelo tribunal, não existe mais a obrigatoriedade de ingressar pela comissão. Então, nós vemos que temos, então, a aplicação, o cuidado, o atendimento da comissão, e essa seria a porta de entrada. Na corte, ela tem duas funções, a corte. Ela tem a contenciosa e a função consultiva. E por isso que eu trouxe aqui a função consultiva, número 28 de 2021, onde ela avalia essa questão da chefia de Estado. Então, dos 31, 32 pareceres consultivos que a Corte fez, esse parecer 28, ele trata justamente do tema da chefia de Estado. Então, aqui vemos como que há essa convivência, trazendo, então, para o primeiro ponto, como que há esta convivência dos países integrantes do sistema americano, seja monarquia, seja república. Aqui eu só trouxe rapidamente para ter uma ideia na nossa divisão no sistema americano. É América do Norte, América Central e América do Sul. Por que nós chamamos a atenção aqui? Vemos que, então, nos sistemas regionais de direitos humanos, nós temos organizados no mundo inteiro o sistema americano, o sistema africano e o sistema europeu. O primeiro que surgiu foi o europeu, em 1950, foi o pioneiro, e a partir dali, todo o seu desenvolvimento foi seguido também por outros sistemas, tanto o americano, que veio depois, em 68, e depois, em 1981, o sistema africano. Então, aqui eu trago só graficamente com o mapa para poder acompanhar e ver quais são os países que a gente vai falar agora, de quais eles têm. E a gente vê que ali em cima, na América do Norte, tem o Canadá e os Estados Unidos. E a gente vai falar sobre eles, se eles estão ou não. Então, rapidamente, a OEA, tal como a União Europeia, ela é uma organização que une os 34 países independente das Américas. Aqui eu trouxe a lista dos países e queria chamar a atenção porque alguns, em 2023, já não estão mais. Então, aqui são os países atualmente que estão integrantes da OEA. E aqui vem a diferença. Primeiro, o país tem que ser integrante da OEA, que nem na Europa. Então, primeiro precisa ser integrante de toda a Europa e depois ser integrante da Convenção Europeia de Direitos Humanos. E a peculiaridade da União Europeia, que é um sistema regional econômico que também tem a possibilidade de aderir, mas ainda até esse momento não fez a adesão completa, porque falta um projeto de acordo que precisa ser autorizado pelo Tribunal de Justiça da União Europeia. Então, por isso que o nosso painel de hoje avalia os sistemas regionais econômicos e de direitos humanos, porque permite que tenha. Qual é a diferença no sistema nosso do Mercosul? O Mercosul ainda não está inserido nessa perspectiva, tal como na União Europeia, que está avançando nesse caminho, porque ainda nós temos aqui no Mercosul a intergovernabilidade, e na Europa, né, ou na União Europeia, é a supranacionalidade. Então, ele é um sistema chamado de sui generis, e por isso ele tem as suas peculiaridades, que atualmente a gente diz que, após a implementação desta adesão da União Europeia na Convenção Europeia de Direitos Humanos, nós teremos um triângulo judicial europeu para o sistema da União Europeia. Então, aqui, voltando para o nosso sistema americano, esses são, rapidamente, os países que estão integrando hoje a OEA. E qual é o fundamento que nós temos da Organização dos Estados Americanos? Nós temos, então, essa carta da OEA, que é um documento que diz as normas que devem seguir para que um país ou ele permaneça ou ele precisa sair por livre vontade ou ele é excluído desta Organização dos Estados. A saída exige uma denúncia formal do próprio país quando ele quer sair e precisa, então, esse período de transição que a gente chama que precisa de 2 anos, avisa 2 anos antes quando ele quer sair, que está previsto expressamente no artigo 143 da Carta. Então, ele ingressa, a partir do depósito lá que ele tem na secretaria, ele ingressa, então, na OEA. A partir dali, depois, ele pode ingressar ou autorizar ou assinar todos os tratados, entre os quais a Convenção Americana de Direitos Humanos. Aqui da OEA, a Nicarágua, ela saiu oficialmente em 2023, por isso que eu chamo a atenção, porque alguns textos ainda trazem a Nicarágua, mas ela saiu em 2023. O governo notificou, então, a OEA em 2021, quando, nessa supervisão que a comissão faz, a Comissão de Direitos Humanos, ou a comissão da OEA, nessa análise que é feita nesse relatório, acompanhando as eleições, que a gente vê que há poucos dias teve a eleição na Colômbia também, né? Então, é sempre feito esse acompanhamento, assim como no Brasil, quando teremos as eleições agora em outubro, haverá esse acompanhamento da Organização dos Estados Americanos para ver se tudo vai bem, né? Tudo caminha bem, para que seja um sistema democrático. A Venezuela, nós acompanhamos mais, né? A situação da Venezuela é algo que é mais frequente de ter se ouvido notícias sobre ela, porque ela é mais antigo, esse problema que teve da Venezuela, se ficava ou não na organização. Então, o processo formal, a Venezuela pediu a saída em 2017, ocorrendo esses 2 anos, então, em 2019, ela saiu da OEA. Tá? E agora a gente vai ver se, saindo da OEA, como é que fica com o sistema da convenção. Quem ingressou na convenção, né? E se faz a saída, que tempo leva, ou como fica a situação para as pessoas que demandam, então, na corte. Aqui, o problema da OEA, só retomando rapidamente o final aqui, o problema da OEA, da Venezuela com a OEA foi a questão do Nicolás Maduro, né? As eleições que teve, e houve, então, não considerado o status político de democracia, e aí houve a retirada. Agora, vemos, então, todo o nosso sistema da Organização do Sistema Interamericano de Direitos Humanos. Então, ingressando na OEA primeiro, passa a ser possível que ele aceite a Convenção Interamericana de Direitos Humanos, ou a Convenção Americana de Direitos Humanos, e que, a partir dali, passa a integrar. Nós temos uma questão específica que a Convenção diz que, quando o Estado parte, ele aceita a convenção, ele tem que depositar esse documento assinado na secretaria, mas ele tem que dizer se ele aceita, então, se submeter aos 2 órgãos institucionais, que é a comissão que faz esse relatório, essa análise, e que os países têm que enviar um relatório dizendo como está se procedendo quanto à implementação dos tratados de direitos humanos na ordem interna, e para a corte. O que acontece, então? Vários países, nós vamos ver, que eles aceitaram, assinaram, ratificaram a convenção, ou quem não estava na Assembleia que organizou a convenção, posteriormente, então, pode aderir, né? E o que aconteceu? Esses países, então, que aceitam a convenção, podem não entregar o documento na mesma data, podem fazer depois a aceitação de submissão para a corte. Foi o que aconteceu no Brasil. No Brasil, aceitou a submissão da corte só em 1998, e a convenção assinou em 1992. Então, vejam que qual é o argumento, então, que os países dizem? Se eles não se submetem à corte, havendo uma sentença, eles dizem, olha, eu não preciso cumprir, porque eu não sou signatário eu sou signatário da convenção, mas não me submeto à corte. Então, essa é uma distinção fundamental para a gente compreender. Outra questão interessante é que podem os países estarem na Assembleia que assinou a convenção, firmou o documento da convenção, mas depois, quando voltaram para os seus países, como o professor Luque explicou bem ontem, a questão do monismo e do dualismo, o que acontece? No Brasil, nós temos o sistema dualista. O Brasil, c'est dualiste, et c'est pour cela que besoin de faire l'approbation do parlamento, etc. E qu'est-ce que se passait? Aconteceu, então, que o Brasil ratificou depois, porque essa é a exigência que se tem, que assine lá na Assembleia e traga no ordenamento interno, se necessário, para o parlamento aprovar, e se não, volta lá daí, e aí entrega o documento assinado. Então, o Brasil fez essa ratificação, assinou, depositou, mas a corte ele não entregou a declaração dizendo que se submetia no mesmo momento, esperou anos depois. Isso é importante que se tenha em mente. Trinidade e Tobago, Venezuela e Nicarágua ratificaram, então elas tinham integrado a Convenção Americana de Direitos Humanos, mas denunciaram o tratado. Denúncia é dizer, eu quero sair. Então, aqui, no lugar de 2 anos, a OEA exige 2 anos. Para a Convenção Americana, a saída exige avisar 1 ano antes, somente depois. O que significa? Durante esse 1 ano de período de transição, pode ser demandado e responde por tudo o que acontecer naquele período de violação de direitos humanos. Então, Trinidade e Tobago foi o primeiro a sair, ele já saiu lá em 1999. A Venezuela, então, deixou de ser parte em 2013 e a Nicarágua deixou oficialmente de ser parte também. A Nicarágua, que foi mais recente, saiu tanto da OEA como também da Convenção. Os países, então, vinculados, e aqui nós chegamos ao tema que o professor Luque falou tanto ontem, né, para nós, a questão se é monismo, dualismo, mas os países que têm ou monarquia ou república. Então, aqui no nosso continente americano, ele é formado por, basicamente, repúblicas. Nós temos somente alguns países que eram monarquia, saíram da monarquia, viraram república ou se tornaram independente, mas mantiveram a sua vinculação com a chefia de Estado. E é o que a gente vai ver, então, quais países que no nosso sistema americano permanecem aqui. E por que isso? O que importa? Importa é quem vai ser responsabilizado, quem vai ser demandado na corte e quem vai ter que pagar a indenização, porque na sentença, em regra, temos indenizações a serem pagas em espécie, indenizações simbólicas e também a determinação de modificação do ordenamento interno para cumprir essa sentença. Então, a gente verá em seguida. O que aconteceu? Nós vemos que tem várias colônias britânicas que, então, se tornaram independentes, né? Hoje em dia, em todos os países não existem mais colônias, né? Ainda praticamente todas se tornaram, pode dizer assim que praticamente, né? Todas se tornaram independentes, mas continuam aceitando que a chefia de Estado fique o monarca representativo. Então, o Caribe, que é aquela parte central que a gente viu no mapa, né? Tem vários países, então, independentes nesse momento. Então, aqui, monarquia mesmo, nós temos 2 países, que é Granada e Jamaica, que eles permanecem estritamente como monarquia. Os outros que se tornaram independentes adotaram a república. Era monarquia, então, Barbados e Dominica, é formalmente uma república. Aqui eu quero fazer uma ressalva. Ainda que se torne uma república, que não esteja mais vinculado à chefia de Estado da Commonwealth. Eles mantêm, existe essa comunidade chamada Commonwealth, que são aqueles países que se tornaram independentes, se tornaram república, mas querem continuar naquele grupo, querem manter essas relações mais próximas. Então, é importante que se saiba, se ficou monarquia, adota aqueles países que se tornaram independentes do Reino Unido, né, da Inglaterra, que a gente chama aqui, esses países, então, a chefia de Estado é hoje o rei Charles, que antes era a rainha Elizabeth. E os que se tornaram república podem ainda continuar sendo desse grupo da Commonwealth, para manter essas relações comerciais, enfim, e outras culturais também, se for basicamente da sua manutenção cultural. Elas são, então, monarquias constitucionais parlamentares, essas duas que eu falei antes, né? E o que acontece? Como ele é representado localmente por um governador geral, o que acontece quando é demandado na Corte Interamericana? As sentenças, quem é demandado e quem depois fica lá como representante é o governador geral. Então, a indenização, quem tem que pagar e resolver é esse local específico, esse território. Não se vincula lá com o Reino Unido. Isso precisa ficar bem presente, porque essa é a grande dúvida que muitas vezes os alunos têm. Mas se lá é a monarquia, ele é o chefe de Estado, quem é que vai representar e quem que vai ter que indenizar? Então, é o próprio território ali e é o governador geral desse território. Isso é bem importante. Então, ainda nós temos monarquia duas no nosso sistema americano e as demais são todas repúblicas. Aqui nós temos que trazer a diferença de quais países que são república e estão na OEA e quais estão na convenção. Como eu tinha falado antes, muitos são da OEA, mas não estão mais, ou não assinaram, não ratificaram. Vejam que os Estados Unidos e o Canadá, eles estão na OEA, mas eles não ratificaram a Convenção Americana de Direitos Humanos por uma questão específica que eles têm no seu país. O que a gente vê? Esses países, então, são membros, mas nunca ratificaram. Consequentemente, não tem qualquer submissão. E aqui são vários deles. Eu chamo a atenção dos Estados Unidos e do Canadá, porque os Estados Unidos estavam presentes na assinatura, mas não ratificaram. Porque uma das grandes questões centrais do sistema americano é a pena de morte. Então, como ainda existe nos Estados Unidos os estados que têm a pena de morte, então os Estados Unidos não ratificou. Então, vocês vão ver que eles estão lá como assinaram. Quando a gente procurar no site ali, que vai lá nos países que assinaram, vai ter na tabela as colunas, vai ter quem assinou, ratificou, saiu ou continua, ou quem só aderiu, que não está no momento. Então, os Estados Unidos vão estar na primeira tabela ali, na primeira coluna, perdão, na tabela, mas na primeira coluna, mas não ratificou, por conta da questão da pena de morte. O Canadá também não o fez por uma questão específica, que se pode dizer de dois problemas. Que há um dispositivo na convenção que fala do direito de propriedade. E o Canadá estava decidindo as questões territoriais dos povos indígenas. Então, para que não tivesse problema, que nem a demarcação das terras indígenas que nós temos no Brasil, para não ter esse problema, eles não ratificaram ou não aderiram à convenção. Então, o Canadá não. E outra questão foi que tem um artigo na convenção que diz expressamente sobre a questão da proteção da pessoa desde a concepção, como nós temos no nosso Código Civil, que se considera pessoa no nascimento, mas se protege desde a concepção. E aqui
o Canadá, ele não tem, é descriminalizado o aborto e tem toda uma regulamentação do país sobre o aborto, e por conta disso, como é uma questão muito específica, também de um artigo da convenção, não aceitou. Vem a pergunta, pode um país aderir e dizer, olha, mas eu quero reserva para tal, eu não quero esse artigo, eu não quero esse dispositivo? Pode fazer reserva. O Brasil até tem, quando o Brasil aderiu à Convenção Americana, fez reservas, e uma delas é quanto a competência da Comissão de Direitos Humanos, que pode vir e fiscalizar. O Brasil disse, olha, eu aceito que venha, mas só se me pede, e para aquela situação eu aceito. Então, o que acontece? Se for feita uma denúncia para a Comissão Americana que está havendo algum problema aqui de violação de direitos humanos, o país tem que ser, o Estado brasileiro tem que ser avisado, dizendo, olha, eu recebi aqui uma denúncia, eu queria ir em loco ali para analisar, eu precisa pedir a permissão. Aí o Brasil diz, sim, pode vir. Não, não pode vir nesse caso. Então, há essa possibilidade. Mas, em geral, com os direitos fundamentais, que a gente vai ver, fica muito difícil para o país dizer, esse eu vou cumprir, esse eu não vou cumprir. Então, em geral, quando é questões cruciais, como pena de morte, né, na verdade, e aborto, então o país já nem ingressa, nem ratifica, para não ter esse problema depois. Tá? Então, esse é um dos, digamos assim, uma das justificativas que nós temos por que o Canadá e os Estados Unidos não ratificaram. Os outros países também, mas eu trouxe esses dois pelo pouco tempo que a gente tem aqui, depois a gente envia para vocês completo o material, e aí fica mais fácil de compreender. Então, a gente vê aqui, ó, na América do Sul, eu listei aqui os países, então a gente vê que a Argentina está, Bolívia, o Brasil, Chile, Colômbia, Equador, Paraguai, Peru, Suriname e Uruguai. Então, países do Mercosul, Argentina, Brasil, Uruguai e Paraguai. Então, os países básicos que começaram o nosso sistema econômico regional, eles estão aqui, tá? Eles aderiram também à convenção. Essa é uma das grandes discussões que nós temos, que tal como na União Europeia, que teve primeiro o sistema de integração econômico e depois veio uma Carta de Proteção dos Direitos Fundamentais, que é a Carta de Nice, que aí integrou direitos fundamentais, também aqui no Mercosul há essa pretensão de fazer essa Carta de Proteção de Direitos Humanos. Até o ministro Gilmar Mendes escreveu um artigo sobre isso, ele é defensor de que tenha essa carta para efetivar essa integração regional. Por quê? É muito mais integrador e fortalecedor dos direitos humanos quando eu tenho uma proteção de direitos humanos expressamente no sistema regional econômico. Então, por isso que se pretende que também tenha essa proteção. Senão, há uma, digamos, uma especialidade só em resolver as questões vinculadas só econômicas e não de direitos humanos. Por isso, então, que nós vemos que na América do Sul, os países iniciantes que são do sistema de integração econômica também fazem parte do sistema de proteção de direitos humanos. Na América Central, então, temos Costa Rica. Costa Rica é importante porque Costa Rica é a sede da Corte Interamericana de Direitos Humanos, é na Costa Rica. É El Salvador, Guatemala, Honduras. Então, aqui, ó, México e o Canadá ficam, né, na América do Norte, né? O Panamá aqui. Por isso que está escrito aqui América Central e México, tá? Para fazer essa distinção, só para não trazer a América do Norte, que era só o México da América do Norte que está integrante. E o Caribe, Haiti e República Dominicana. Aqui eu queria chamar a atenção, porque quem olhar a composição da OEA vai ver que tem Dominicana e República Dominicana. Por quê? Porque a Dominicana é vinculado a uma colônia que era do Reino Unido e que continua. E a República Dominicana é para mostrar que ela é uma república. Então, tem as duas que continuam integrantes para fazer essa distinção. Então, muitas monarquias, aqui eu trouxe, né? Muitas monarquias conhecidas das Américas, que estão aqui, são membros, mas nunca ratificaram, então nunca entraram, só para fazer uma síntese aqui dessa parte, que eles eram, então, monarquias conhecidas das Américas, né? Então, poucos, até como não é tão usual, né, a questão do Canadá, poucos lembram, né, quando a gente estuda no dia a dia, poucos lembram que ela tem, então, a chefia de Estado como o Reino Unido, né, a chefia de Estado no Canadá. Se começou a ter uma noção um pouco de discussão sobre esse tema da chefia de Estado quando teve o filho da rainha, né, da princesa Diana, né, que saiu da família ou se afastou e a discussão era se ele ia morar no Canadá ou nos Estados Unidos. Então aí começou essa discussão como é que ele ficaria morando no Canadá, com a questão da rainha ser a chefe de Estado na época, tá? Então, aqui só para trazer para vocês os dispositivos que eu já comentei, né? Desde a concepção, porque os estados, então, um dos problemas é a pena de morte, que é o artigo 4º dos direitos fundamentais, dos direitos humanos que estão protegidos, e direito à vida desde a concepção, que é o artigo 4.1. Também outra questão é liberdade de expressão, artigo 13.5, e no caso também dos Estados Unidos, eles justificam a supremacia constitucional. O que eles alegam? Que a Suprema Corte dos Estados Unidos não aceita que outra corte internacional diga sobre as decisões que eles tiveram. Então, esse é um dos motivos pelos quais os Estados Unidos não ratificaram a convenção. Então, aqui eu trouxe, só para trazer para vocês, o Canadá, a questão é da população indígena, que eu já comentei, são as primeiras nações, e essa era a grande questão, que é o artigo 21. Então, ele está vinculado à motivação ao artigo 21, que é o direito de propriedade. Qual é a questão aqui principal, que diz respeito também ao tema que o professor Luque trouxe e ao tema que o professor Reverbel tanto fala no federalismo e que é o mestre, o nosso doutor aqui no tema, como no Canadá tem a questão das províncias, eles nunca conseguiram que as províncias autorizassem a adesão. Por conta disso, nunca aconteceu essa adesão à Convenção Americana. Tá? C'est tranquille? Pas bien? Après, j'ai envoyé la traduction en français. Mais quelque chose que vous demandez, pouvez demander. Oui. Então, aqui não ratificaram, né? Que não. Aqui eu quis trazer para vocês, então, o que é esse sistema, que um pouco eu falei no início, mostrando que o sistema é formado, então, pela Convenção Americana de Direitos Humanos, por 2 protocolos facultativos específicos. O que significa isso? Esses protocolos, tal como na União Europeia, primeiro sai a convenção com o texto básico e todo mundo chegou a um consenso, um acordo para aqueles países signatários reconhecerem, então, toda essa organização, esses institutos e os direitos. A partir dali, conforme avançam as negociações entre os países signatários, começam a fazer protocolos adicionais para que integrem ou sejam sequenciais, digamos, não fiquem dentro do próprio texto, mas também seguem como protocolos adicionais. No caso, então, do nosso sistema americano, é considerado, para que seja submetido à corte, não só, então, os dispositivos que estão na convenção, mas também, então, esses protocolos adicionais e todos os demais que forem feitos depois específicos. Por exemplo, nós temos a convenção Internacional das Pessoas com Deficiência, que ele é global, é vinculado à ONU. E a princípio, ele não integra essa discussão pela Corte. Então, o que vai ser olhado? Só aqueles regionais, principalmente, que o país aderiu. E a gente ouviu falar muito da Convenção de Belém do Pará. No nosso dia a dia, para os alunos, fica fácil, porque no Brasil todos conhecem a Lei Maria da Penha. E a Lei Maria da Penha, ela não é uma condenação da Corte, e sim uma recomendação da comissão, que é o primeiro passo, é a porta de entrada, e o Brasil resolveu aceitar a recomendação, que dizia basicamente 3 situações. Tinha que indenizar, que, regra geral, essa é uma das primeiras questões, indenização em dinheiro para as vítimas ou seus familiares. Então, no caso, ela ganhou a indenização. Uma indenização, então, em dinheiro, em espécie, que a gente chama, uma indenização simbólica, e por isso que a Lei Maria da Penha teve o nome de Maria da Penha. Então, essa é a indenização simbólica que ela recebeu, e uma obrigatoriedade de modificação dos normativos internos, ou seja, fazer uma lei específica de proteção da perspectiva de gênero, que foi isso que aconteceu com a Lei Maria da Penha. Então, houve uma grande discussão no Brasil, desde que houve a Lei Maria da Penha, se aplicava para quem, se era constitucional, inconstitucional, enfim. Essa decisão já toda foi superada, o nosso Supremo Tribunal Federal já decidiu sobre isso, então ela é constitucional desta forma e não viola o artigo 5º, que é a igualdade de gênero, que diziam então que ali ela era mais protetiva para o gênero. Tá? Então, só para dizer que, frisar, que também a Convenção de Belém do Pará, ela integra o nosso sistema. Mas o principal, a gente pode dizer, a convenção mais 2 protocolos. Nós temos, então, a Convenção Americana e mais 2 protocolos, que fazem parte, então, do sistema protetivo, mas também a Corte, na hora de julgar, vê todos os outros tratados que cada país aderiu. E aqui vem a questão. Nós temos um tratado regional de direitos humanos, que é o Tratado Regional das Pessoas chamadas maiores. São as pessoas aqui no Brasil nós chamamos de pessoas idosas, né? Mas em espanhol, mesmo às vezes em Portugal, vocês vão ver muitos textos escritos Convenção Regional para Pessoas Maiores, tá? Em espanhol é majores, né? Mas elas dizem respeito a pessoas com mais de 60 anos, que são as pessoas idosas. Esta convenção regional, ela é de 2015. A Argentina já implementou, o Brasil ainda não ratificou, tá? Então, o que acontece? Enquanto o Brasil não ratificar, ela não entra, então, numa condenação do Brasil, essa convenção. Só que o Brasil tiver ratificado ou aderido quando o caso for para a Corte. E por isso que grande parte das demandas a Corte diz, olha, eu não vou aceitar esse caso, eu não aceito que eu seja responsabilizada desse caso, porque quando esse caso aconteceu, eu ainda não tinha me submetido à sujeição da Corte. Então, aqui eu trago as outras convenções que eu já mencionei, né? Principalmente aqui, formas de discriminação contra as pessoas. Vejam, e aqui que eu queria chamar a atenção, a Convenção Internacional das Pessoas com Deficiência, que é a global, ela só veio em 2007, que ingressou no nosso ordenamento em 2009, mas nós já tínhamos uma convenção regional para as pessoas que aqui era chamada portadores de deficiência, mas hoje não se usa mais esse termo, mas eu trago que é o nome da convenção, e hoje é das pessoas com deficiência, né? E não portadoras de deficiência, tá? Só para deixar claro que esse é o nome da convenção, então ela está lá expressa, mas hoje o nome modificou. A leitura do nome, como nós designamos, né, é as pessoas com deficiência. E por que eu chamo aqui a declaração? O que acontece? A declaração, vejam que interessante, a nossa Declaração Americana de Direitos Humanos, ela é de 1948, tal como a Declaração Universal de Direitos Humanos, com a diferença que a nossa convenção, ela foi foi assinada em junho, na metade do ano de 1948, e a Declaração Universal só em dezembro. Então, nós temos aqui no sistema regional uma Declaração Americana de Direitos Humanos, precursora, inclusive, daquela que estava sendo discutida na ONU. Tá? Então, vejam, e o que acontece, então? Aqui vem uma questão. Aqueles países que não ratificam a corte, a submissão da corte, ou mesmo de direitos humanos, em geral, se utiliza esse argumento na comissão para análise quando não ratifica a corte. Tá? Quando adere à convenção, mas não à corte, se utiliza para levar para a corte a discussão só se atender ou não à declaração. Tá? Mas, de qualquer forma, o que é o mais importante saber? Se o país não se submeteu à corte, ele diz, olha, eu não vou cumprir, mesmo que vá o caso para lá. Mas, em geral, também há uma dificuldade da corte aceitar o caso se a parte não aderiu. Tá? Então, essa é uma questão importante. Aqui a gente tem a questão, a Convenção Interamericana sobre Desaparecimento Forçado das Pessoas, né, que nós vemos. Eu coloquei aqui as que o Brasil internalizou, por isso que estão também alguns dados ali de algumas datas, né, que é quando nós internalizamos. Por quê? Como a gente estava no período da ditadura, mesmo que tivessem convenções anteriores, pouquíssimas, o Brasil, quando se trata de direitos humanos, ele internalizou. Então, ele só trouxe para o nosso ordenamento interno a partir da reabertura, né? Então, por isso que é de 1992 adiante que nós temos vários tratados de direitos humanos que foram internalizados. Aqui, interessante, o que é essa suspensão, né? Então, aqueles países que estão na OEA, que não cumprem, ou vê que não estão cumprindo os requisitos que tem que ser Estado democrático, não ter violação de direitos humanos tão evidentes, né? Eles podem ser suspensos, e nesse período da suspensão, se eles estiverem também vinculados à Convenção de Direitos Humanos, eles continuam sendo demandados pela convenção, ainda que suspensos da OEA, tá? Então, só para ter em mente que isso é bem importante, continuar tendo uma competência para monitorar a situação. Então, a comissão continua olhando aquele país e fazendo relatórios. Então, a comissão, ela envia esses relatórios depois dos países, enfim, ela faz aqueles relatórios anuais de controle, mas de tempos em tempos ela fiscaliza efetivamente um país e faz um e-book, que a gente diz, né? Faz um relatório global e lança um livro. Então, tem um material disponível no próprio site da comissão que todos podem acessar. É muito fácil para acessar. Tem alguns relatórios que são em português mesmo, porque os idiomas do nosso sistema da convenção é português, inglês e espanhol. Então, sempre lembrar que no nosso sistema americano, os básicos são a convenção e a declaração. São os básicos. A nossa aqui para trazer que, embora ela seja de 69, no Brasil, ela entrou em vigor lá, a convenção, em 78, mas no Brasil só em 92. Pelo decreto 678, de 1992. Aqui só quero chamar a atenção que esta declaração, então, houve uma grande discussão no Brasil sobre qual é o status, qual é a hierarquia desse tratado no nosso ambiente interno. E aqui a gente viu que em 2008, na grande discussão sobre o artigo 7.7 da Convenção sobre a prisão civil, a possibilidade de prisão civil, então, naquela oportunidade se decidiu pelo Supremo Tribunal Federal que a Convenção Americana de Direitos Humanos ela tem um status supralegal, embaixo da Constituição, mas acima das leis. E chamando a atenção, então, que a partir da nossa emenda constitucional 45 de 2004, nós tivemos com a reforma, chamada Reforma do Poder Judiciário, a inclusão no artigo 5º do parágrafo 3º, que permite que se traga para o nosso ordenamento como norma constitucional, que foi o que aconteceu com a Convenção Internacional das Pessoas com Deficiência, que entrou no nosso ordenamento como norma constitucional. Aqui o que eu tinha trazido para vocês, que o Brasil fez reserva, isto é, dos artigos 43 e 48D, que não incluem o direito automático de visitas. Então, aqui, atualmente, se tiver algum problema, precisa avisar o Brasil e esse vai dizer se aceita ou não a visita. Os dois protocolos. E aqui, então, só para trazer rapidamente, que eu quero passar adiante, que são, então, 3 partes na nossa convenção, que onde estão os deveres dos estados, os meios de proteção e as disposições gerais. Quero chamar a atenção que nos 3 modelos, tanto no sistema americano, europeu e africano, os 3 eles têm essa divisão entre os direitos e deveres, os meios de proteção e as disposições gerais. O que aconteceu no nosso sistema americano? Nós ainda temos a comissão e a corte. No sistema europeu, só tem meio de proteção a própria corte. O sistema europeu é diferente. No africano, ainda tem os dois. Mas no africano, o que aconteceu? Não há especificamente, na Convenção Africana, não tinha previsão da corte, ela veio depois no protocolo. Então, quando alguém lê a Carta de Banjul, da Carta Africana de Direitos Humanos, não vai ter a menção à corte, porque ela foi feita depois, tá? Essa menção expressa. Essa é a diferença. Estou tentando trazer rapidamente uma comparação, até para facilitar que se compreenda como vai ser depois, quando o professor falar sobre esse tema, ou o professor Reverbel, para compreender como são os 3 sistemas. Então, aqui só para trazer que dos deveres, então, o nosso ponto central para a chefia de Estado, ele está basicamente no capítulo 1, que é a enumeração de deveres do Estado. Então, aqui, e nas decisões da Corte, quando a gente vai envolver a representação do Estado, a chefia do Estado, então a gente vê que ela, nas decisões da sentença da Corte, vai olhar nos primeiros artigos que tratam dos deveres do Estado. Em geral, nas convenções é assim, qual é o dever do Estado, o que ele se compromete, depois vem os direitos das partes, tá? Que são os direitos civis e políticos, econômicos, sociais e culturais, suspensão de garantias e deveres das pessoas. Chamo a atenção aqui que a Convenção trata também de deveres das pessoas. Aqui, então, a comissão, a corte e disposições. Eu quero só trazer, então, quais são os artigos. Nesse artigo primeiro, eu vou passar um pouco mais... Não vai adiantar, né? Já faz bastante. Aqui, eu só quero chamar atenção para vocês, então, quando se trata de chefia de Estado, nós vamos olhar especificamente no artigo 1º, que é deveres do Estado, e no artigo 2º, e depois, especificamente, na proteção judicial nos deveres, que é o artigo 8º e o artigo 24, que ali é o direito das pessoas a ter um juiz imparcial, um juiz natural, e ter acesso à justiça, que aí são nos direitos das pessoas. O que chama aqui, então? A enumeração é dos deveres no capítulo 1 de quem? Do Estado. Então, o Estado tem obrigação de respeitar esses direitos. Os Estados partes comprometem a respeitar os direitos e liberdades reconhecidos e garantir o livre e pleno exercício a toda pessoa sem discriminação. É obrigação. Que aqui a gente vê que esse dispositivo basicamente é o nosso artigo 5º, né? Todos são iguais, sem discriminação. Então, basicamente, está na nossa Constituição. Para os efeitos, pessoa é todo ser humano, tá? Então, todo ser humano é considerado pessoa. E aqui, então, eu trouxe para vocês uma sentença da Corte Interamericana, no qual ela traz esse dispositivo. Que aqui, quando eu trago o número 411, é o parágrafo da sentença. As sentenças da Corte Interamericana são divididas pelos pontos, pelos títulos, mas ela segue sequencialmente cada parágrafo. Cada parágrafo diz o que deve ser cumprido, o que ela está falando. Então, quando a gente tem o número 411, quer dizer que é o parágrafo 411. São sentenças curtas, não muito longas, justamente porque cada ponto é muito importante, ele tem que ser olhado com muita atenção. Aqui, o que ele diz? Da jurisprudência da Corte pode-se deduzir, então, que é o que nos interessa. A responsabilidade nacional do Estado, segundo o artigo 2º, é que não apenas por uma lei interna que viole a Convenção, mas também quando funcionários do Estado, ao aplicarem uma lei, a interpretarem de forma que viole os direitos protegidos. Aqui vem uma grande discussão que nós temos sobre o controle de convencionalidade. Vocês vão ver que o CNJ agora, na sua organização, que nós temos essa institucionalização do CNJ, que é o Conselho Nacional de Justiça, expressamente previsto na nossa Constituição, e ele determina que esse conselho, ele organiza as normas para a magistratura, para todo o poder judiciário do país. E o Conselho Nacional de Justiça, então, o que ele fez ultimamente? Ele organizou isso e fez recomendações e resoluções para o poder judiciário, que estão sendo implementadas. Uma das últimas delas diz que cada estado deve fazer uma unidade de monitoramento estadual ou regional que cumpra as sentenças da Corte. Mas o que ele considera sentenças da Corte? Decisões da Corte. Não só aquelas que é diretamente vinculado ao Brasil, aqui no Brasil. Não só as do Brasil, mas todas aquelas sentenças que, de uma maneira ou outra, podem fazer aplicação também. Vou dar um exemplo. Nós temos, no Brasil, a sentença, a primeira sentença que nós temos de condenação em todo o sistema americano, de condenação de trabalho análogo à escravidão moderna, que foi contra o Brasil. Então, é nesse sentido. Se é uma decisão, aqui no caso, excepcionalmente, era também do próprio Brasil, então é mais fácil seguir e observar. Mas digamos que fosse em outro país, quando começa a primeira, essa também, por ser a primeira de alguma matéria que o Poder Judiciário está decidindo no nosso ordenamento, nos processos, também tem que observar. Então, podemos dizer assim que houve uma modificação significativa no Brasil após 2021, quando o CNJ ele participou de uma audiência pública que foi feita com a Corte Americana sobre esse cumprimento dessas sentenças, e a discussão era na supervisão de sentença da primeira sentença que o Brasil foi condenado, que é da Damião Ximenes, e que diz respeito à desinstitucionalização das pessoas com deficiência dos hospitais psiquiátricos, né? Das clínicas de internação. Então, todo esse movimento, e a partir dali, o CNJ começou a fazer resoluções ou protocolos específicos para que o Poder Judiciário tivesse uma espécie de manual. O protocolo, o que ele é? Aqui eu quero fazer uma diferença. Qual é a diferença entre um protocolo à convenção e esse protocolo que o CNJ chama de protocolo? Ele chama, então, tipo um manual de obrigatoriedade de prosseguimento. Seria um formulário que deve ser observado por ordenamento interno dos juízes, no caso, que é o protocolo para julgamento com perspectiva de gênero ou protocolo para julgamento com perspectiva racial. E agora tem também um protocolo, a partir de fevereiro desse ano, protocolo para a aplicação desse monitoramento. Então, hoje, podemos dizer que está bem integrado essa obrigatoriedade, e a gente vê também que nos concursos para as provas do ENAM, que agora a Magistratura Nacional faz um concurso nacional prévio, né, que se diz que vale para todo o país, existe, então, já os temas de direitos humanos, são 5 questões que impactam, então, no resultado. Então, vejam que no resultado, na decisão, na seleção do candidato. Então, vejam que agora essa questão ela é muito demandada e ela é difundida para que todos os alunos tenham a noção e todos os profissionais eles saibam que não basta só conhecer a sua matéria específica, direito empresarial, direito civil, mas temos que saber também as convenções e as sentenças e como aplicar e como requerer isso no nosso dia a dia. E eu posso dizer assim que esses protocolos, quando eles têm os considerando, os protocolos nacionais que eu estou falando do CNJ, ali nos considerando, tem os normativos legais, tanto lei nacional brasileira quanto as convenções. Então, quando o advogado for aplicar ou o juiz for aplicar, ele pode olhar nos considerandos para ter o fundamento legal para fazer o seu pedido. Só quis trazer, então, esse caso aqui, que esqueci de mencionar, esse que eu estava falando. Então, ele é o caso Cruz, Sanches e outros, versus Peru. Então, não foi um caso brasileiro, mas eu trouxe aqui que é um dos primeiros. Eu selecionei, não vai dar tempo de falar aqui todos, vários que foram, inclusive, que aplicam para essa situação que eu estou falando, do controle de convencionalidade. Eu vou enviar depois para vocês esse material, porque são vários. Tem dos países, então, não só esse, mas também das últimas sentenças que houve a condenação do Brasil. Então, são bem recentes, então eu vou enviar para vocês depois pelo material, tá? Pela escola. A gente vai disponibilizar para vocês. O que eu queria chamar a atenção também, o que significa, isso é bem importante, controle de convencionalidade. Quem faz o controle de convencionalidade no nosso sistema americano é a corte. Por quê? Porque lá ela diz, eu aqui vou olhar a convenção, que é um tratado internacional, e eu estou submetido por esse tratado, eu tenho essa competência, vou olhar e vou fazer a interpretação. O que no Brasil nós estamos chamando, e o que o CNJ, então, está falando para fazer o controle de convencionalidade? Ele está dizendo para o juiz nacional, olha, que controle é esse? Dizendo que aquela sentença que foi feito o controle lá pela corte, já foi feito esse controle, como que eu vou aplicar aqui? Como que o juiz nacional vai aplicar se o nosso sistema, o máximo que nós temos é de constitucionalidade? Muito simples, porque todas as convenções entram no nosso ordenamento por um decreto legislativo, seja com força constitucional agora, ou infraconstitucional, ou supralegal, no caso da convenção e as outras de direitos humanos. Então, ele está formalmente dentro do nosso sistema constitucional, porque todos os nossos juízes nacionais fazem o controle constitucional, e o controle constitucional brasileiro, ele integra a análise dos tratados de direitos humanos. Qual é a diferença do sistema europeu, que o professor fala? Como na União Europeia existe a supraconstitucionalidade, isto é, existe um parlamento, existe todo um ordenamento supranacional que faz as normas e integra automaticamente quando é um regulamento, que nem o regulamento da proteção de dados, ou existe uma normativa que precisa ser internalizada, dependendo se é monismo ou dualismo, né? Mas a diferença é que lá, pelos tratados internacionais, o juiz nacional já faz a competência do controle de convencionalidade, porque ele tem essa competência, aonde ele vai olhar no tratado da União Europeia e ele tem essa competência. Então, eu só chamo esse cuidado para quando for ler o que é esse controle de convencionalidade, que alguns autores falam e o que ele significa quando está dizendo que o juiz brasileiro, ele não vai fazer o que a gente chama de controle de convencionalidade como lá na corte, porque ele não tem essa competência de interpretar. Ele vai pegar as decisões que a corte já interpretou e aplicar, porque no nosso ordenamento interno, nós somos submetidos àquele normativo que é constitucional. Qualquer dúvida quanto a esse aspecto, a gente pode explicar depois, mas isso é muito importante, porque muitas vezes pode dar interpretações equivocadas do que o CNJ está falando, o que é o controle de convencionalidade que os juízes têm que aplicar. Aqui eu só queria chamar a atenção, vejam que o Supremo Tribunal Federal começou, então, aos poucos, trazer essas decisões e trazer a menção à questão interna, à aplicação dos tratados de direitos humanos na ordem interna. E aqui a gente tem, em 2016, o relator foi o ministro Luiz Fux, numa ADI, que é Ação Direta de Inconstitucionalidade, dizendo que o Pacto da Costa Rica, então, no sistema deve ser exercido para aferir a compatibilidade entre uma norma supralegal e uma norma legal. Então, ele disse que no nosso ordenamento interno, quando eles estão falando do controle de convencionalidade, eles vão olhar se a Convenção de Direitos Humanos está sendo observada por uma lei infraconstitucional. Por quê? Porque o Supremo disse que ela tem norma supralegal. Mas o que eu quero chamar a atenção aqui? Para evitar que o juiz tenha que fazer dois controles, né? Ele faz o controle de constitucionalidade, mas sabendo que o que o CNJ e o Supremo chamam de controle de convencionalidade é saber que se existe, então, uma lei que vai discutir com a convenção, que é o decreto 692, vai prevalecer a convenção americana. Nesse sentido que ele diz que vai fazer esse controle de convencionalidade. Tá? Essa é a interpretação que ele diz, o que significa controle de convencionalidade no âmbito interno. E não que, e aqui é bem importante, é isso que ele ressalta aqui, e não que a Convenção de Direitos Humanos vai valer mais do que a nossa Constituição. Tá? Ele tem que ser a Convenção de Direitos Humanos, ela é infraconstitucional. Agora, a Convenção Internacional das Pessoas com Deficiência, ela é constitucional. Então, essa global. E mesmo as regionais que entrarem no nosso ordenamento agora como norma constitucional, então, nesse aspecto, o controle de convencionalidade, ele vai olhar como direto controle de constitucionalidade, porque não vai precisar fazer essa relação entre a Convenção Americana e a lei só. Vai fazer direto com a Constituição. Então, aqui eu trouxe, então, o parágrafo 88 daquela decisão sobre o controle de convencionalidade, que é... Deixa eu voltar aqui. Aqui é um caso da sentença da Corte Interamericana de Direitos Humanos, o caso do filme Tentação de Jesus Cristo. Muitos talvez não lembram, mas esse é aquele filme que foi proibido no Chile, né? Então foi decidido que não poderia fazer essa proibição. Então fez um controle de convencionalidade, que também vem esse caso, a última tentação de Jesus Cristo, que é o Medo, Busto e Outros, da versus Chile, mérito, reparações e custas. O que significa isso aqui? Mérito, reparações e custas. No sistema americano, nós podemos fazer a sentença integrada entre preliminar e mérito. Quando se trata de Estado, quando é contra um Estado, pode ser a Corte decidir que vai decidir na mesma sentença já tanto as preliminares como o mérito, ou fazer separado. Este caso aqui, ela olhou primeiro se em preliminar, se tinha competência, ou se aquele Estado podia ser demandado. Então, ele fez uma sentença separada. Então, essa sentença já é a segunda sentença sobre o caso. Então, você tem que tomar cuidado para ver se vocês estão com a sentença preliminar ou mérito. No caso aqui, é mérito, reparações e custas. Quem paga as custas, né? Então, aqui as reparações que eu falei. Então, geralmente, a sentença trata da preliminar ou do mérito com as reparações e as custas. Tá? Meu tempo é pequeno, então... E o dever de exercer, então, de ofício, esta obrigatoriedade de cumprimento. E adotar medidas positivas para modificar. Aqui trago também essa decisão com voto da ministra Rosa Weber, nessa ADI 4275, relator é o ministro Marco Aurélio, de 2018-2019, trazendo, então, no parágrafo 11, né, essa discussão que a Corte Americana abordou a categoria da orientação quanto à identidade de gênero e trouxe a decisão. O que eu quis mostrar trazendo essas decisões do Supremo Tribunal Federal? Vejam que a partir já de 2016, antes também, mas a partir de 2016, nós temos casos específicos falando do controle de convencionalidade obrigatório para o ordenamento interno pelo Supremo Tribunal Federal. Então, quando a gente vê que o número é grande do parágrafo, em geral, é uma sentença, tá? Ó, caso Furlan e familiares é caso da Argentina. Aqui se trata da duração dos processos judiciais, que nós temos na Convenção Americana, existe um dispositivo específico para a duração razoável do processo, e o Brasil, na reforma do Poder Judiciário, com a Emenda Constitucional 45, trouxe um dispositivo expresso no artigo 5º, no inciso 67, para a duração razoável do processo. Tá? Então, aqui também, nós temos vários. Aqui, principalmente, estão vendo os parágrafos, diz respeito, mas também interpretação, também nesse caso, é o caso brasileiro da guerrilha do Araguaia, que é o caso que discute a questão da lei de anistia, né? Caso Gomes Monte. Então, eu vou encerrando por aqui, porque senão demorei demais, mas para ter uma ideia de como, tentei trazer comparado, de como esse nosso sistema americano, ele também leva em conta a chefia de Estado, que muitas vezes nós não prestamos a devida atenção, e como nós já temos decisões do Supremo sobre esse tema. Eu vou passar, então, a palavra de imediato. Tá. Fechou. Vou passar, então, a palavra para o nosso ilustre professor Heuschling para nos trazer as suas considerações.
Hey, thanks very much once more for the great honor and pleasure to be here with you, and to thanks also for the very interesting and stimulating presentation of the Inter-American system from perspective from inside, because in Europe we know, of course, about the Inter-American system, but we have a perspective from outside. And it's very interesting also to have your perspective from Brazil of this system. Now, today I would like you to present two facets about Europe with regard to this topic of today, which is the question of human rights, question of dualism, monism. And today I will present you a rather different perspective on different issues. I will present you on the one side the question of very particular question, very exotic question for Republicans like people in Brazil. It's a question whether the monarchs and the royals in general, so the members of the royal family in monarchies, whether they do have human rights in general, and more particularly, because this is of course a very broad topic, but more particularly the right to vote. So that will be the first topic. And the second topic I will present is the question of monism and dualism, because in Luxembourg we have implemented since 19th century, since the beginning of the existence of the state of Luxembourg, so since the 1st January of 1831. That's the exact birth date of the state of Luxembourg. We can define it very precisely. It's at midnight of 31st December and 0 hour of 1st January 1831. So since the beginning of the existence of a state of Luxembourg, we have implemented, well, the lawyers at the time, have implemented the principle of monism, and the principle of monism in its most radical form, so primacy of international law over all internal norms, including the constitution. Now, this is, of course, a very radical paradigm, a very rare paradigm. As you surely know, this principle, this approach to the interaction of internal law and international law has been theorized in a very famous way by the Vienna School and especially by Kelsen, Verdross, and Kunz. And this is a very famous theory, but most of you will consider that this is very rare, and it is very rare. So the question is, why is it possible that a country accepts such a very strange paradigm? Because it submitted the entire internal legal system to international law. How is it possible to conceive of such a system? And why did Luxembourg implement this system? And as I told you, we are in 1831, so there is no influence of Kelsen, definitely. So it's not due to Kelsen. Luxembourgers at the time were no Kelsenians. So how does it come that in Luxembourg, in this small country, and I think that is very important, it was a small country, and I think that other small countries at the time had the same approach, because the size of the country makes a difference. It's not the only element to consider, but it is an important element. The other element which I will stress is the monarchy. So there is in the context of Luxembourg, there is a strong link between monarchy and monism, and I will show you that in a second step. And we still today keep that monism, although it is a little bit disturbed by the membership of Luxembourg to the European Union. Now, I'll start first with the question of the right to vote of monarchs and more broadly royals. Now, I use the term royals to encompass all the members of the royal family, so including the monarch. But sometimes I will need to distinguish between, on the one side, the monarch, head of state, and the other members. But I also use the term royals as an all-encompassing term. Now, to start with that point, there are two ways to start. First, you may ask me, why are you interested in that topic? And this is an interesting question, because I think I'm the only specialist in Europe and maybe in the world on this topic, because definitely nobody, or let's say I'm one of the rare. There are some lawyers who discussed it in the past and even today, but this topic generally is not dealt with. It's considered to be a very marginal or even a non-topic. Personally, I discovered the topic because I'm Luxembourger, and in Luxembourg, in the elections, the fact that some, not all, some royals in Luxembourg participate to the election is an event. It's a social event. So the media all talk about it. And this is something which is common to, it's common to other countries like Spain. In Spain, the fact that Juan Carlos, the king Juan Carlos, participated in the referendum on the transition from the dictatorship to the democratic system, because there has been at the end of the dictatorship a referendum, and it was a key element that the king himself participated in the referendum, and of course everybody understood that he voted in favor, of course, in this event. So in some monarchies, it is a social event. It is a social event in order to show that the royals are now democrats. That monarchy, to some extent, is even democratic with regard to voting rights, And if I had been in Liechtenstein, I would, of course, know this topic, because this topic was at the heart of the big crisis in Liechtenstein in 2002, 2003. So this topic in some monarchies is not just a non-topic, it is a crucial topic. And as I will show you in Liechtenstein, this topic was even dealt with by the courts, and there is a court decision on this topic. And I think it is the only, and this topic has also been discussed recently in 2019 in Thailand. And it was also in Thailand in 2019, it was at the heart of a political crisis, because the sister of the acting king at the time, and the current king still, the sister, a very famous princess, very famous and very popular royal, which wanted to be the leader of a political party, and not just any political party. It was the political party. It was the opposition party, and the party was opposed to the military coup d'etat, and which was opposed even to the king. So you can imagine that in Thailand in 2019, the question whether that princess could have the right to vote and to participate in an election, so to stand for election, of course, was a key issue. So it is, in some countries, in some monarchies, it is a very highly controversial issue. Another way to start to present the topic is to say, well, for you Republicans, maybe you do not see the topic, because in a republic, it is obvious that the head of state, the president, and of course, the wife, his spouse, or his partner, or his man, if you have a female president. Now, it is obvious that the person, the individual who is the holder of the office of president, and of course, all his or her family members, they have the voting right. They do vote. They can stand for election if, of course, they comply with the usual ordinary criteria of being elector, being enrolled on the electors list, and fulfilling the criteria like nationality, age, and residence, of course. So for you Republicans, it is obvious. This is not the topic. It is obvious. But for monarchies, it is a topic. Because, as I said, in some monarchies, royals, all or some, have the right to vote, but not the right to stand for election, often. But in some monarchies, none of the royals has neither the right to stand for election, nor even simply the right to vote. So you can see that between republics and all republics, where the solution is simple and homogeneous, we have on the other side the monarchies, where you have a strange diversity of solutions, because all the monarchies do not have the same solution. And you may ask, what is the rationale for this difference between the monarchies and the republics? And what is the rationale which would explain the diversity inside the democratized monarchies? Now, in order to introduce you into that topic, I will deal with it a little bit historically, and I will distinguish 4 steps. And I will simplify the history, and you will see that why at a certain moment I will ignore a very crucial event in this historical narrative. I will put it at the end and not at its right moment in history. So I will just very brief comment about ancient regime, which is very important. One needs to go back to ancient regime. First step. Second step, dualism. So I already spoke about 19th century dualism. This question of dualism is a question of power organization, but it has also, and that is very interesting, it has an impact on the question of the human rights and especially the voting right of royals. So that is dualism in 19th century. And of course, I will raise the question of Brazil, because Brazil was in 19th century an empire. The third step is I will go into 20th century and I will look into the countries which today, even in Europe, are still dualist monarchies. And I will look into Liechtenstein. Liechtenstein and Monaco, I will ignore Monaco. I will only look into Liechtenstein. So what is going on in Liechtenstein, which is still implementing dualism like in the 19th century, but at the same time, it's not anymore 19th century dualism. It's a new, more Swiss, direct democratized dualism in the fashion à la façon of Liechtenstein in 2002 and 2003. So dualism in 19th century is something else than the dualism today in Liechtenstein. So that is the third step, dualism in Liechtenstein in 20th century and 21st century even. And then the fourth sequence I will present is 20th century or 21st century monarchies which are not adhering anymore dualism, which have overcome dualism, so which are, to say differently, which are not simply 50% democratic, they are 100% democratic. The whole system is supposed to be democratic, and monarchy is just, as I told you yesterday, a question of appearance or form. So what is the situation in a system which formally is still monarchical, but substantially should be entirely 100% democracy? What is the situation? And I will look into that. And at that moment, I will come back to the French Revolution. So I talk about the French Revolution at the end and not at the beginning. And you will understand why. Okay, let's go on in this historical narrative. Let's start very briefly with ancient regime. It's very easy, but it is important to keep it in mind, because I think there is a strong link between ancient regime and dualism of 19th century. Ancient regime, there are no parliaments at the time. No parliaments as we understand them today, but there were some representative organs. There were, for example, in France, the États généraux du royaume, the general estates of the kingdom, and those representative organs in those absolute monarchies were, to summarize, they were only consultative. They were, let's say, mainly consultative. There are some debates whether in France the general estates had the power to decide about some taxes, but generally the estates were more conceived as bodies which were consultative. Interesting, what is the most interesting for us, those bodies were considered to be bodies which represented the subjects of the king. So it was very clear, you had a very clear distinction between above the king, and I would add immediately the king and his family. So the dynasty, the whole family, not just the king, it was the king and the other members of the family, which were above. And then you have the society. The society and even the aristocrats were part of that society, because the aristocrat with the poor people, the ordinary, the third estate, and so on, the bourgeoisie, they were part of the society which were represented in those representative bodies. So on the ancient regime, there was a clear distinction, and I can give you lots of definitions, ordinary definitions of what is a subject, what is a subject of the king, what is a king, and all the definition in the dictionaries of France, Germany, and so on, they all insisted for 18th century, the king, of course, is not a subject of the king. This is obvious. And the representative organs are organs which represent the subject of the king. So already for the ancient regime, if you would have asked, does the king have a power to participate in the appointment process of those representative organs, you would say, of course, obviously, no, and nobody raised the question. Nobody raised the question because it was obvious, because those bodies only represent the subjects, and the king is not a subject. And whether the royals, the other royals, the princesses and the princes were subjects to the king, this is a tricky question, but I leave it aside. But definitely the king himself was not the subject of the king. So keeping in mind that ancient regime, I step immediately into 19th century. So I ignore the French Revolution. I ignore the beginning of the Enlightenment process. And I ignore only France, because only France was, at the beginning of the revolution, the modern revolutions, at the end of 18th century, only France was a monarchy. The United States were republics. The large majority of the American, South American, and Central American states, modern states which emerged as republics. So they didn't discuss the topic of whether the monarch and the other royals would have, in a modern representative system, whether they would or not have the right to vote. But in France, given the fact that France in 1789, 1791 was still a monarchy, they had and they did discuss the topic. But I will leave it aside for the moment. So I'm stepping now into dualism. Now, dualism, we are 19th century. We have dualism, we have the legislative body is split roughly in two elements. On the one side, the king still, which has the crucial prerogative of sanctioning the law, and the other side, you have parliament with generally two chambers. you have now electors, you have voters, a legal definition of voting rights and the right to stand for election. Question, what about the royals? Can royals be elected? Can they stand for election? Can they stand for election for the elected chamber of parliament? Do they have the voting right? This question is, in 19th century, a question which is not dealt with precisely, directly by the legal documents. This is interesting because for French Revolution, we will have explicit provisions. But for 19th century, none of the monarchies, the constitution I've read, and I've read a lot, 19th century. I think I've read almost all the constitution of the monarchical constitution of 19th century. None of the constitution speaks directly about the question of the right to vote and the right to stand for election of royals, of the monarch or the other royals. In the Brazilian constitution, there is nothing. So I also looked in not all, but quite a lot of electoral statutes, electoral legislation. I do not know about Brazil, so I'm curious to know what happens about Brazil, but what is the content of the Brazilian Electoral Act. But my hypothesis is that there is nothing about the royals in the act. I can tell you, I have read all the electoral acts of Luxembourg in the 19th century. A colleague from Turkey, for example, has read for me the electoral act of the Ottoman Empire. Once the Ottoman Empire had a parliament, an electoral process, and in all those cases where I considered the acts, there is nothing about the royals precisely. So there is no exception for the royals. There is no sentence saying the general conditions also apply to royals or do not apply to royals. There is just the ordinary condition, and that's all. So it's a question of interpretation. Because if you interpret those conditions, you will start by saying, well, do they have the nationality? That's a very interesting question. Has the monarch of the country the nationality of the country? It's sometimes a tricky question, but it's practically, it's not a question of passport. Kings do not have passports. They do not need that. So, but there were discussions in 19th century at some moment, does the monarch have our nationality? The answer is because at some moment the monarchs got also a passport, so the question of the nationality needed to be settled, and generally the answer is, yeah, they have nationality. So they have the nationality. First criteria is satisfied. Do they have the age? Well, yes, at some moment they have the age of 19, 20, 24, 25, depending on the age you needed at the time. Well, the princesses, of course, are, if you apply the gender criteria, they're excluded, but the male princes of the royal family, they would be included. Do they live in the country? Often, not always, because think about the cases where, like today, Charles III is living in London, but is the king of Canada, and so on and so on. So the residence is often given, but not necessarily. In Brazil, it was given once you had your own dynasty and your own independent country. So if you apply, do they pay taxes? Well, that is a tricky issue, because at the time they did not pay taxes. So does that mean they were excluded because of the fact they did not pay taxes? Interestingly, to give you the result of my empirical studies, I looked into the archives of Luxembourg, and the archives of Luxembourg, we still have the electoral registers of all the elections. So the archives are there, and I looked into the list of electors of the city of Luxembourg, because in the city of Luxembourg, the registers were all kept. And interestingly, so I looked from 1842, the first year of existence of a parliament in Luxembourg. So I looked from 1842 till today, well, till the beginning of the 21st century. And interestingly, what I discovered for Luxembourg was that before 1945, no royal was ever registered on the electoral list. No royal at all, none. And the list is relatively short, so I could really look into, in the 19th century, the list of electors was very short, very small, so it was easy to check. And in 1945, so the first elections after because during Second World War, Luxembourg was occupied, there was no parliament anymore. So the last election in Luxembourg was in 1939. So 1939, none of the royals was on the list. And in 1945, once Luxembourg was independent once more, and there were new elections, curiously, they were added to the list. Not all royals except the monarch. And interestingly, the monarch at the time was a woman. That's very important. So the monarch was a woman, and she had a man, she had a husband, and the husband was on the list. He was on the list of electors. And consider also that in Luxembourg till today, participation to elections, once you are enrolled on the list, participation is compulsory. And for Luxembourg, due to the photos in the media, I do know that those who were on the list did indeed participate. And there were some very interesting comments in the newspapers where they said with a kind of ironic comment, well, look at our royals. Those who are always the first, now they have to queue behind a small civil servant, and behind there is a car driver. They are just ordinary people, and they also have to queue. And in Belgium, you also have those photos where the journalists say, oh, look at our previous king, our previous queen. Look, now they have to queue like any ordinary Belgian citizen. So it's, there is a democratic discourse narrative about they are ordinary. They are just ordinary citizens. So the question is now, so empirically, I could show that in Luxembourg, there was no registration of the royals, all royals, whereas after 1945, they were listed, except the monarch. And then I discovered, when I looked later what was going on, when there was a change of the monarch and the Queen Charlotte stepped down, and there was a new Grand Duke, a male Grand Duke, João. Interestingly, neither him nor his wife was on the list. So curiously, the husband of the reigning queen was on the list, but once the head of state was a man, the woman, his wife, curiously disappeared. And that gender difference goes on till today, which is interesting. Is that compatible with equality? So empirically, from 19th century, I can prove for Luxembourg, none of the royals were on the list. And I guess, because I couldn't check that, of course, in other monarchies in 19th century, I think if you would do the job in Brazil, looking in the so it would be Sao Paulo or Petropolis, whether Pedro II was on the list, whether the Queen, the Empress was on the list, I would guess you would find nothing. Why? Of course, now you can ask, and I did ask myself, why legally weren't they on the list? And I looked into the literature, not in the Luxembourg literature, there was nothing about it. It's a non-topic. But in the Belgium and the German literature, I found marginal comments on this question. Why? In Belgium, it's very funny. In Belgium, there is a famous article written by an anonymous article in a very prestigious encyclopedia. So the author was surely a very distinguished lawyer, because it was a very distinguished, famous Belgian legal encyclopedia. And the topic was a very sensitive topic. It was a topic about royal family. So you imagine they would not give that article to kind of radical communist, or they gave it to probably a very distinguished high-level jurist. We do not know whom, but that's most probable. And if you read this, it's very interesting, because you think this is a lefty who wrote that. This is a radical who wrote it, because he envisages questions which you normally you would never envisage. Like, he envisaged what will happen if a royal commits a criminal offense. Sorry, how do you dare even considering that the royal member of the family would in 19th century commit a criminal offense? Of course, today in Spain, this is usual, this is usual business. This is kind of ordinary topic. But in 19th century, this is almost lèse-majesté. You suggest that maybe the members of the royal family are not of utmost virtue. So he asked, what happens if they commit a criminal offense? And he said, we just apply ordinary criminal law, unless there are exceptions. Are there exceptions? Yes, no. But the general reasoning was, we always accept ordinary law unless there is an explicit or maybe implicit exception. So the assumption is royals are not different from the beginning. They are part of the society, the nation, the citizens, but of course there may be for them some specific exception, but those exceptions must be proven. And then he goes on at the end, and there you see his kind of little bit weird, radical mind. He says, and what about elections? And he says, I don't have a clue about it. I don't know what is the practice. I don't know whether they are on the lists. I don't know whether they vote. So he hadn't done any empirical research. But he said, but legally speaking, they are subject to the Electoral Act. There is no exception. So for me, they should vote. But I do not know how the matter is handled in practice. So you see that here we have a very radical approach, a very democratic approach, where the royals are not separate from the society, they are part of the society. Now, one more precision, this article, royal family, does not speak about the king. It's the other royal. The royal family is defined as the other members. So everything the author says is about the others, not about the king. So we do not know what he thinks about the king, but we do know what he thinks about the other royals. So the other royals, the queen, the presumptive heir, and all the other princesses and princes. So here we have a very radical democratic approach. Now I will go into the German literature. The German literature, you had both very liberal minds, professors, and you had very conservative professors. And we will see the two parties. First of all, there was a general discussion about, do royals have fundamental rights? That was a broad discussion as such. Not about voting right. You will find nothing in the textbooks about, do royals have the voting right? No, that is a non-topic. But if you look into all the textbooks at the time, you will find a question like, who are the holders of the Grundrechte, the fundamental rights? And then very often you have a small paragraph, do the royals, the other members of the family, other than the king himself, do they have the fundamental rights? Are they holders of those rights? And the liberals like Robert Mohl, Hermann Schulze, Hermann Rehm, beginning of 19th century, the middle of the 19th century, and the end of 19th century, they reply, yes, of course, of course. Of course, why? Well, they are Germans. So all the Germans have fundamental rights. All the Bavarians have rights of Bavarians. All the Brazilians have rights of Brazilians. They are Bavarians. They are citizens of Württemberg. So they have the rights of the citizens of Württemberg. So they have the nationality. So they also have the rights. So there is a broad answer like they do have human rights, fundamental rights. And then you have some conservative who just reject that thesis without very much explaining this refusal. They say no. And there you can hear a reminiscence of ancient regime. The rights are not for the king, not for the royals. The rights in the constitutions are for the people. And the king and the royal family, of course, are not the people. So the rights in the constitution are for the others, not for the king and his family. Now, when you look more precisely in the German literature about voting rights, you really have to search. You have to search. But interestingly, at the end of 19th century, there had been a very small debate. So about whether the kings, the monarchs, have the right to stand for elections. Now, think about it. professors in Germany in 19th century are discussing, writing articles about, with title, do the monarchs have the right to stand for elections? Why is this a topic? It's a topic because it's a joke, due to a joke, because in the elections, some of the electors put the name of the king on the ballot. And then, of course, you have a legal problem. Is this an invalid ballot? You just delete it? Or is it valid? And then you have to count it. And the parliamentarians who had to decide, and the professors who had to comment, they mostly considered that, of course, without having thought a lot about it, they just said, of course, they don't have the right to stand for election. This is not, doesn't make sense. And there was one law professor who explained very quickly in one sentence. He said, this is obvious. And it was a Bavarian law professor, a very famous Bavarian professor, Seidel, end of 19th century. He said, well, this is of course evident. All the royals, and of course also the monarchs, they do not have neither the right to vote, nor of course, a fortiori, the right to stand for election. Why? Well, because of dualism. Hey, stupid, it's dualism, that's all. Why dualism? Well, because what is parliament? Parliament represents the society. Yes, but what is society? The nation or the society? Well, it's this, not the strangers, the foreigners, of course, only the nationals. But what about the king and the royal family? And there, the answer of Seidel is, but parliament represents the subjects of the king. Parliament is a representation of the subjects towards whom, in front of whom? Well, towards, in front of the king. So you have dualism. So you have on the one side, the king who has the sanction, the power of sanctioning the law. On the other side, you have parliament, the power to vote the project, the draft of a bill. And behind each of those state organs, there is a social group. Behind parliament is a group of nation, the people, the nationals, and behind the king, well, there is a king himself, and there are the royals. The king represents his own perception, his own political opinion, and the opinions of the royal family in the legislative process. And therefore, of course, it is logical that the king cannot not vote for parliament, because if the king could vote for parliament, he would be on both sides. He would be on the side of the royal family and the position of king, and he would be a member of the society voting for parliament. So he would influence both organs. He would be the incumbent of the holder of the office of king, and he would be an elector of parliament. Now, in a system of dualism, you cannot be on both sides. That is not logical. That's not coherent. So, in a coherent manner, the king is on the one side, and the others are on the other side. And the foreigners are nowhere, of course, in this system. And this is, for me, dualism is the general explanation which, for Luxembourg, explains why the royals in 19th century in Luxembourg were not, it's not the fact that they didn't pay taxes. My guess is it's due to dualism. Now, that's second sequence. Now I come to the third sequence. Third sequence is now Liechtenstein, which is still today a dualistic system. So the prince has the power to give or refuse the sanction to a bill. And there is the Landtag, the parliament of Liechtenstein, which has the power to decide about projects. There are no aristocrats in Liechtenstein, so we do not have to consider the problem of aristocrats. Where do they stand? But there are, of course, royals, other members of the family, and apparently the family of Liechtenstein is very big. It's very big family, and this is quantitatively an important element, because consider the fact there are very few electors in Liechtenstein. So if you add all the princesses and princesses of the family to the number of electors, this has a quantitative impact. Of course, in other countries, it has no impact. You know, what one vote more or less doesn't make the difference. But in Liechtenstein, it makes a difference. So what is the solution in Liechtenstein? Normally, you would say, well, it's dualism, so they cannot have the right to vote because they're on the one side, not on the other. But the situation in Liechtenstein currently is weird. They are on both sides. So they are, the prince is prince, head of state, has the right to sanction the law. There is parliament designated by the electors, and all the royals of Liechtenstein, when they live in Liechtenstein, because all do not live in Liechtenstein. You know, if you know Liechtenstein, it's not the most attractive place to spend your life. So those who live in Liechtenstein and who have the age of 18 and they do have the nationality, they are registered. And especially Hans Adam, the prince, and the heir to the throne, Alois, they were registered in 2002. In 2002. The date is important. Why? In Liechtenstein, they do not know, no researcher knows since when the royals in Liechtenstein were put on the list. Nobody has researched it, so that's not known. But in 2002, they were on the list. Why? Is that important and known? In 2002, Hans Adam, reigning prince of Liechtenstein, is not happy about the constitution of Liechtenstein of 1921, as it was at that period, because he considered that even though the constitution of 1921 was still dualism, he considered that he should have more power. So he launched first a project as head of state. As head of state, he submitted via the government a constitutional reform draft to parliament. The ordinary process to reform the constitution is through parliament. He tried, the majority of parliament rejected. This is not democratic. It's too much, too much. You have already a lot of power, but now you're even asking for more. That's too much, too much. And the Council of Europe indeed said that this reform, this project, was not very democratic. So they were very critical about it. But Hans Adam did not abandon his project. So he couldn't get it through parliament, but then there is another possibility. citizens, we are in Liechtenstein, so we are almost in Switzerland. So citizens of Liechtenstein can trigger a referendum on the constitutional change. And they can propose the change. And the system is when, I think it's 1,500 citizens, if there are 1,500 citizens who propose an amendment, the amendment goes immediately to referendum. So it's really an initiative coming out of the people and going directly to the people. Parliament can just give an advice, can make a comment about the draft, but Parliament cannot block the draft. So Hans Adam had the problem, if he wanted to trigger this reform by this popular citizen initiative, he needed to be a citizen. Question, was he a citizen? Did he have the political rights of a citizen? He was a national, he had the age, he was residing in Liechtenstein, and at the time they looked into the list of electors and they found, well, he is already, apparently, he is already on the list of electors, he and his son. So they can propose the initiative. And of course, you imagine all the politicians who were opposed to the reform, they felt totally, this was, they were totally totally out of the game. They had nothing to say anymore, unless they criticize in court the initiative by saying, but they are not citizens. They are members of the royal family. So they went to court, the administrative court, and they criticized the validity of the initiative by saying, we are in a dualistic system and you cannot be on both sides. You are on the one side or the other, but not on both. And interestingly, the matter went to administrative court. There is only one level, one instance, and the administrative court rejected the file, the complaint, and just did not discuss dualism, which would have been logical. The court just said, but look, they are already on the list of electors. So they comply, they satisfy all the criteria of being elector, of having the political rights. So they do have the rights. So the initiative is valid. And the initiative was a success because the initiative was approved by a rather large majority in the referendum of 2003. And so the huge reform of the Liechtenstein Constitution of 2003 entered into force. And the crucial element was the right to initiate a referendum, to trigger a referendum. Now let's go on to the fourth sequence. So let's look now into the monarchies in Europe and even in Japan, because I have some information about Japan and Thailand. In the monarchies, which are supposed to be, let's say, roughly 100% democratic, no dualism anymore. The king is not to have really a right to veto an act of parliament. So the system is supposed to be democratic. What would be the logical outcome of such a system with regard to the question of the right to vote of the monarch as private person? Because it's not the king who is voting. It's not the Grand Duke of Luxembourg who is voting. That's a state organ. A state organ doesn't vote. It's the private individual called Henry, called Louis XVI, or whoever, or Prince d'Orléans, who can potentially vote or cannot vote. And here I have to go back to French Revolution, because one of the most famous thinkers of the French Revolution discussed that topic. And guess who it was? It's one of the most famous, and it's not Robespierre. It's not Robespierre. It's not Robespierre. It could have been, because he was very radical. But was not Robespierre. We are in 1789, 1790, 1791. Who would you think of maybe as one of the really most famous members of the National Assembly in Paris?
Yes.
Yes, yes, yes. And I think you even know the speech in which he developed that argument. Guess in which speech? He gave a series of speeches, but there is one famous speech in particular. It's on the speech on the royal veto. So a lot of people who know about CS know he was totally opposed to the royal veto. And there is this famous speech on the royal veto. That's the title, the speech on the royal veto. It's not the veto, it's the right to sanction the bill, but that's not the problem. And interestingly, in this speech, he talks about the right to vote of the king. Not of the king, he says of the individual who is sitting on the throne. So he makes a difference between the roi et l'individu qui occupe la fonction de roi. So he talks about the private person, Louis de Bourbon. But interestingly, I went into the literature about CAS, and I looked into what do all the people who wrote about CAS, what do they say about the right to vote of the king, of the individual who is king, by the way. And interestingly, all the 90% of all the philosophers, sociologists, lawyers who discuss this very famous speech totally ignore the issue of the voting rights. And if you once more read this speech, you will see that this is a total misunderstanding of CAS. And this is really unfortunate, because CAS gives a series of arguments, but the strongest argument is an argument where it links the right to veto and the right to vote. And he says, if you have the right to veto, you cannot have the right to vote. And if you do not have, or because the king will not have the right to veto in the system of CAS, he should, in the system of CAS, have the right to vote. So either the right to veto or the right to vote. If you take this speech, it's CAS if we accept a veto, we are in a dualist system. The veto of one person outweighs the decision of parliament representing millions of people. So one individual, one is bigger, outweighs the wish of millions. And this is, of course, for him, unacceptable. So he rejects the right to veto. But he says, Louis, he will not be granted as king the right to veto, because this is unacceptable in a democracy. He doesn't say democracy, in a representative system based on equality. But in his system, the king was supposed to be present in the assemblies, the primary assemblies, electing the deputies of the National Assembly. That was his system. No right to veto, but the right to vote. And therefore, you can see in the system of Sieyès, which is a very democratic, the king, the royals, are all members of the society, and they do all have the right to vote, and they should be members of the primary assemblies and then vote for deputies in the National Assembly. Now, interestingly, this discourse, as you know, on the question on veto had no impact because he rejected totally, and the majority of the Constituent Assembly in France accepted the veto. And as you may know, Sieyès he was not a good speaker. He was a very bad speaker, everybody says, and nobody could understand him, you know. So I think this speech, yes, was published, people read it, but in the assembly itself, nobody heard it. Nobody understood it. So this speech was totally ignored later, except by some people later. Later, in 1790, so the speech of Sieyès was 7th September 1789, and then there was a second discussion. And this discussion took place in August 1791, so 2 years later. It was really the end of the discussion about the future constitution. So it was almost the last point to be discussed with regard to the future constitution. And the question was the following: should the other royals, there was no discussion about the king, should the other royals have the right to stand for election, meaning also have the right to vote, but to stand for election? What is the legal situation of the royals in general? That was the big question. And then there was a precise question: should the royals, the other royals, have the right to stand for election? Should they be potentially members of the future National Assembly? And you have to remember that at that moment, there was a royal sitting in the National Constituent Assembly, Philippe Égalité. He was member of the royal family, and he was even an opponent to Louis XVI. Philippe Égalité, who later voted the death penalty of King Louis XVI. And he was one of the radical members of the assembly. So the question was not theoretical, it was practical. Would you like him to sit even later in the future National Assembly? Would you like other royals to sit in the future parliament inside our future system? And there were some supporters of Philippe d'Égalité who say yes. Why? Because the assembly before had said that the royals, so the other members of the royal family, they were, in principle, ordinary people. They were, that was the provision they put in the constitution. They were subject to ordinary law unless there was an exception. So if we apply this principle to the question of election, the outcome is, of course, they should have the right to vote and the right to stand for election if they fulfill the various ordinary criteria. And that was the first conclusion of the debate. And then the resistance started, because there were some opponents to Philippe d'Égalité, and they couldn't accept that. So there were some discussions. And the outcome was a compromise. And it was this compromise was put in the text of the Constitution. The text as adopted, so the text of the Constitution of 1791, the first modern monarchy in continental Europe, constitutional text which later inspired the famous Spanish Constitution of 1812, the Constitution of Cadix, and the text of 1791, which inspired, to some extent, the Portuguese Constitution of 1822, and already the constitutional basis of 1821. You can find crucial provisions of 1791 in the Portuguese text. So in the French Constitution of 1791, there are two provisions which I want to quote. There is one first who says, to put it familiarly, the other members of the royal family they are subject to ordinary law. That's the first general statement. And then there are precise exceptions. With regard to voting, they say those other royals, they have the right to vote, but they do not have the right to stand for elections. So no Philippe Égalité anymore. So there you see, there is a partial exception to the principle of equality. And then there are some other exceptions, like, for example, if those other royals are ordinary people, can they become a minister? And you do not need to be elected to become minister. You just need to be appointed by the king, who is the head of your family. And of course, you know, in the monarchies of the Arab countries, like Saudi Arabia, the Emirates, and so on, a lot of, not even all ministers of the government are mostly members of the reigning royal family. So the royal family has a lot of power in those monarchies because they occupy the function of head of state, and they have their word to say inside the government. Now, the French revolutionaries, they were aware of the danger that King Louis XVI later could appoint his members of his family as ministers. So they said they can become ambassador. They can become civil servant, higher civil servant, of course. Imagine. they may be officer in the army, but they would need the approval by parliament, exception, but they cannot become minister. Please, no minister, not minister. So you see that here you have, in the French Revolution, you have a debate about, should we just apply equality to the royals, principle of equality, or should we consider them to be outside the society, dualism? Or should we consider they are inside the society, they are ordinary, but there are some exceptions. And if there are none exceptions, we have just to apply the usual rules. Now I come to 20th century, 21st century. We now have those monarchies which substantially are to, let's say, 100% democratic. There is no dualism anymore. The monarch, in principle, has no veto right anymore. So do they have now the right to vote, the right to stand for election? The answer is, it depends on the country, on the monarchy. So to give you a short list, the list of monarchies where all or some royals have the right to vote. Netherlands, since 1917, so the end of the First World War. Netherlands was neutral at the time, so it was not occupied, was not involved in the war. And in Netherlands, during the war, the democratization process went on. So they implemented general suffrage for men and for women, 1917, 1919. And in this context, on the debate of general suffrage, they considered that the royals had the right to vote, but there was an exception, and the exception was they were not obliged to use it because all the others were obliged. Netherlands implemented an obligation to vote at that moment when general suffrage was also implemented. So we have, the principle is implemented, but there is an exception. In practice, in Netherlands, in the past, there were some royals who voted, but today, none of the royals uses the right to vote. There are no photos, there are no social event about the participation of the royals to election, but they do have the right to vote in the Netherlands. Second country, Luxembourg. Second country in history to implement the right to vote is Luxembourg, 1945. And as I said, all except the Grand Duke, and if it is a woman, the married partner of the head of state. If it is a man, well, there is a precedent. If it's a man, apparently the man could claim the right to vote. If it's a woman, she cannot. This is a practice. Of course, I criticize it. It's totally incompatible with the principle of equality and the principle of equality. Third country is Italy. Italy, there was a referendum, a famous referendum in Italy about keeping the monarchy or introducing the republic. And we do have photos where you can see that the king at the time, Umberto II, participated in the referendum. So apparently he had the right to vote at that moment, at least. I do not know how he got it, when he got the right, but we do have proof, evidence, it did participate. And of course, the royalists used the participation of the king in order to say, let's vote for monarchy. Our monarch is a modern monarch, and so on. Fourth country I would quote is Sweden. Sweden, 1974. You remember Sweden in 1974 abolished totally the two voices normativity system. So the king, the head of state, doesn't sign no document anymore, has no power, of course, except the power to give speeches, to shake hands, to organize social events. And in the context of this major democratic reform of 74, the Swedish constitution introduced also an explicit provision about the question of voting rights. And they said that they only introduced an incompatibility rule. So, meaning the text says you cannot be on the same moment head of state and member of parliament. But that means, and that is how all the literature understands this provision, it means all the royals, including the king, has the right to vote and even the right to stand for election. Spain, as I mentioned, in the context of the transition process, Juan Carlos participated in the referendum, so he had the right to vote, apparently. I do not know on which legal ground. I do not know whether they had some discussions in literature. I guess no, but that's just a fact. There are photos which prove he attended the referendum. And today, the Spanish literature says that all the royals have the right to vote in all the elections. They have the right to participate to referendum, but they do not have the right to stand for election. And that is written in the electoral law. Let's come now to the countries which reject any right to vote to the royals. I will present very quickly 4 countries: Japan, UK, Denmark, and Thailand. Japan. Now, Japan is a fascinating case because remember that before 1945, the tenor was not a human being, strictly speaking. He was almost a god. So, to some extent, you could say, anyway, he's not ordinary. So, all the discussion, do royals have the right to human rights, human dignity, and all freedom of expression, freedom of conscience, doesn't make sense already for the tenor. But in 1945, Showa Hirohito, if you say it differently, the emperor gave his famous speech, which was very complicated, and most of the people at the time didn't understand it because it was a very sophisticated, complicated court Japanese language. So ordinary people were unable to understand it. What he said is that he wasn't anymore of divine nature. So he was now a human being, and all the other royals now were to be considered as human beings. And during the process, the debate on the future constitution of Japan of 1946, there was a general debate about, do the royals, the members of the imperial family of Japan, are they holders of fundamental rights? The answer is yes. In the debate, the clear answer given by the government was yes. And today, in the textbooks on human rights in Japan, you will always find at least a sentence or a paragraph about holders of fundamental rights, and you will have a paragraph about the members of the imperial family are holders of the fundamental rights. But what about the right to vote, which is a little bit more political than, but even freedom of conscience is political, because the emperor is supposed to be a representative of the Shinto cult, of the Shinto religion. So he has not really freedom of conscience. But don't speak about that. I won't talk about that. Let's talk just about the right to vote. And the government said, during these debates, the government said they do have in general the fundamental rights, but they do not have the right to vote, the right to stand for election. None of the members of the imperial family has such political civic rights. Why? Principle of neutrality. They must be beyond politics. Being beyond politics, well, means that you should at least minimum understanding. You should not express any political idea. Should you be allowed to vote? Well, if you go voting, you somewhat show that you have political ideas. But at the same time, you don't express it. We do not know for whom you vote. And honestly, we all know that all royals have political ideas. You know, in Luxembourg, it's obvious. We all know in Luxembourg that our royal family is very conservative, Catholic, and very conservative. We know it. You know, they told us. So nobody thinks really that they are neutral in the meaning they don't have political ideas. They have, we even know them. And in our system in Luxembourg, at least all the other royals, they vote. So we imagine they vote for a party. Which one, we don't know, but we imagine they vote for a party. And we accept it. It's not a problem for us, you know. It's not a problem for neutrality. Neutrality is a matter for us, for the head of state, not for all the family members. But in Japan, it's a matter for the whole family. So the limit of neutrality is a limit which is opposed to all royals in Japan. Second example, UK. Now, UK is also a fascinating case because it's a hypocritical system, totally hypocritical. Now, I don't know whether you're well aware of the intricacies of the definition of constitution in UK. But in UK, you have two meanings of the word constitution. Constitution means constitutional law and constitutional conventions. Constitutional law are legal norms. Constitutional conventions are non-legal norms, political understandings, political expectations, which are not, which cannot be used and implemented in court. And that is the difference between legal and non-legal in the British understanding. If you can use a norm in court, it becomes legal, it is legal. If you can't use it in court, it is non-legal, even if, for example, the rule would be in a text called Act of Parliament. So this distinction between law, constitutional law, and constitutional convention is very important on our matter, because today, if you go on the website of the Royal Court of UK, you will find information about the voting right. Why? Because lots of people in UK, they want to know, does Elizabeth II vote? Does she have the right to vote? Does Charles III has the right? You know, it's a frequently asked question. So the website, of course, gives an answer to frequently asked questions. And the answer is the following. Now, I give you the most recent one because the answer evolved during time. I registered at least 2 versions of the website. So the current website, when I made the research, so the last research 5 years ago, so it was, at the time, it was still under Elizabeth II, the website said, according to law, all the royals have the right to vote. Why? Well, because they are, well, they satisfy all the criteria of the Electoral Act. So that is interesting. In the past, in UK, there was an interpretation rule, a very classic interpretation rule. In 19th century, for example, an act is only applicable to the king if the act precisely mentions that it should be applied to the king and to the royal family. Meaning, if the act says nothing, if the act is silent about the king and the royals, the act does not apply. That was a past, because the Election Law Act doesn't talk about neither the king nor the other royals. So, because in the meantime, if you look into the textbooks in UK, now the traditional classic interpretation rule, acts do not apply to the king unless it is said so, this interpretation rule is abandoned. That means that if an act is silent, it applies to the royal family. And that is what they did with regard to the election matter. They applied the ordinary criteria to the royals and said they are British, they have the age, they live in UK, so they have the right to vote and even to stand for election. But, very important now, but there are some constitutional conventions, not legal rules, because you can't find an exception in law. There is a convention, so non-legal rule. And this convention is called neutrality. Neutrality. And this convention implies that all royals should abstain from using their legal right to vote and a fortiori their legal right to stand for election. But legally speaking, they have the right, but they shouldn't use it. So I call this system hypocritical, because if ever somebody would go to the Strasbourg court and say our system is not, the British system is not democratic at 100% because our royals do not have the right to vote, the government could say, oh, there is no issue. They have the right to vote, legally speaking. But given some conventions, they should not use it. Last example, Denmark is, neutrality is a non-written rule. And Denmark, in the constitution of Denmark, there are lots of non-written constitutional legal rules. So in the Danish literature, it is well accepted that custom, non-written constitutional norms may contradict or complement the written text. The written text doesn't talk about rights, but there is a non-written principle of neutrality, so they don't have the right to vote, nor to stand for elections. None of the royals in Denmark has such right because of neutrality, the unwritten principle of neutrality. And the last example is Thailand. I told you in 2019, now in February 2019, you may remember that in Thailand there was a very strong, controversial politician called Thaksin Shinawatra. And this politician was even at some time prime minister, and then he was ejected by a military coup d'etat. He was even, I think, sentenced to prison, and his party was abolished by the courts. But his supporters in this party was very strong party. The supporters of Thaksin Shinawatra created new party with new people with the same ideas but a new name, and this party was also once more prohibited, annulled by the courts, and then they created a new party. And in 2019, the party was called the Thai Raksa Chart Party. And the party, at the time, the leader could not be Thaksin Shinawatra. It couldn't be. So this party always needed to have another leader, and they looked for different leaders. And that moment, 2019, they got hold of a very prominent personality, because the previous princess, and I insist on previous, the previous princess, Ubal Ratana, which was the older sister of the king, Rama X, she was a very popular, the most popular member of the royal family. She is even more popular than the king. The king has, if you may know a little bit about Thailand, the current king is not at all popular. She was immensely popular, and she had left the royal family formally. So she wasn't anymore, legally speaking, a royal, because she wanted to marry an American husband, and therefore she needed to leave the royal family. So they choose to have freedom of marriage and to leave the royal family. So legally speaking, it would have been easy to say she is no royal. So there is no issue. She can, of course, be the leader of that party, and she can stand for election. But of course, the royal court, the king, did not appreciate at all. And he even said so in media. He gave a speech where he said that the leadership of his sister was inappropriate and unconstitutional. Now, unconstitutional. Why should it be unconstitutional? The text of the Constitution at the time did not contain any explicit provision, did not contain any exception to the ordinary criteria to become elector. So, given the fact that she is legally not a royal anymore, one should just apply the ordinary criteria, and then, of course, he should have the right. But you should remember that the first modern constitution of Thailand, the famous constitution of 1932, that constitution contained an explicit provision about royals. And the Constitution of 1932, Article 11, said that the other members of the royal family, other than the king, they should keep out of politics. It's very broadly formulated. It's really, they should not get involved in politics at all. Now, this provision is not part of the constitutional text in 2019, but if you keep in mind that provision, and you may consider that this is maybe part of a kind of tradition, well, you understand the result of the speech of the king, and you will understand the decision of the Electoral Commission, which on the 11th of February 2019 rejected the list of that party, considering that the leadership of a royal member of a royal family is unconstitutional. So there you see how the matter is dealt with, especially in by reference to implicit norm. Now, here it is not neutrality really in the case of Thailand. The Commission refers to neutrality, but Thailand, the king is not really neutral, and he is still a very influential political person. So talking about neutrality in the case of Thailand is a little bit hypocritical. It is a useful argument because you can consider that Thailand then is a 100% democratic system because the king is neutral, but this is not really the case. So that's all I wanted to tell you about the right to vote, the very diverse situation. Now I'm looking at the time, it's 12 o'clock, so do we still have some time for monism? How much, or shall we just stop here? What do you suggest?
About monism.
Okay, so maybe just 10 minutes then about monism. So, as I said, the Luxembourgish state was created in 31st December of 1813 by a document signed by the Grand Duke William I, a document dated 31st December 1813, and that act entered into force the 1st January 1831. So therefore, the 1st January 1831 is the date of birth of the Luxembourgish state as an independent state. And this state was created under very special circumstances. To rough it up, to be very short, at that moment, legally speaking, the territory of Luxembourg belonged to the Netherlands. It was just a province of the state of Netherlands. So it was not a state, it was a province simply. It was a part of the state of the Netherlands. Then the Belgian people in Brussels during summer 1830 started the Belgian Revolution, and proclaimed the independence of all the southern provinces of Netherlands, including the independence of Luxembourg as a part of Belgium. So in Brussels, the revolutionaries created a new state called the Kingdom of Belgium, which included Luxembourg. So we had, at that moment, for the same territory, Luxembourg, we had two legal systems which claimed to be the owner of that territory and to have sovereignty over the people living on that territory. De facto, empirically speaking, Luxembourg, the province of Luxembourg, was divided. The city of Luxembourg was occupied by Prussian troops, which maintained the right of the King of Netherlands to his sovereignty over the whole Luxembourg. But outside the city of Luxembourg, the whole territory outside of the city of Luxembourg was occupied by Belgian troops. So, empirically speaking, the Belgian state implemented its own claim on Luxembourg on almost 90% of the territory, and it was only 10% of the territory which was still in the hands under the legal system of the Dutch constitution. In this context, now it becomes even more complicated. William I decides that in order to save Luxembourg, he would use two instruments. He would use military force, but that didn't work. So the only tool he had was a legal tool. The legal tool was create now a new state, the Luxembourgish state, on the territory of Luxembourg. Why is that useful to keep his power in Luxembourg? Well, the goal was to change the mind of the people in Luxembourg. Because the majority of the people in Luxembourg so far, they obeyed the Belgian Revolution. They supported the Belgian state. So he tried to get their support by telling them, but hey, people, hey, Luxembourgers, I create now a state for you. It's your state. Don't listen to those guys in Belgium, Brussels. They are rebels. Obey your king. I'm your monarch. And that is good for you. You know, it's your interest because you will have now your own state. You're not part anymore of the Belgian state, not part of the Dutch state. It's your state. You will have your own legal system. And you will have your own taxes. So you will pay less taxes because you will pay not the Dutch taxes, which are high, I know. You will pay the Luxembourgish tax, which will be less. You will be civil servant of the Luxembourgish state. You will have positions. You will have your own government. And I promise you, you will even get your own parliament. Just obey my rules. Don't listen anymore to the Belgian rules and forget about Netherlands. Well, that is a little bit weird because how could William I create a new state because according to the Dutch constitution, Luxembourg is a province, not a state. And according to the Belgian constitution, Luxembourg was a province, but not of William, but of Belgium. So the problem of William was he needed to get rid of two constitutions. Of course, the Belgian one and the Dutch one. Because the Dutch constitution said Luxembourg is part of the Netherlands. So how do you get rid of two constitutions? Well, he found an argument, because if you look into the Dutch constitution, the solution is, in order to make out of a province, a Dutch province, an independent state, you need to change the Dutch constitution. You need to rewrite it, and therefore you need the approval by the king and the approval of the Dutch parliament, with the special majority, of course. And in December 1813, there was no time to launch such a reform, and probably there was no majority. So he needed to get rid of the Dutch constitution without applying the rules of the Dutch constitution. So how can you do? Well, you can do if you use a legal norm which is above the Dutch constitution. Does that exist? Yes. And it's not natural law. It's not natural law. It's international law. So you see, monism, primacy of international law. But what international law? What is interesting in international law in order to establish a state in Luxembourg? Well, the famous Treaty of Vienna, 1815. And the Treaty of Vienna says that there is a certain territory in Europe called Luxembourg. And who is the owner? Who has sovereignty over this territory? And the treaty says the King William I. So the Treaty of Vienna gave the sovereignty on Luxembourg not to Netherlands, but to the family of the Nassau, whose head of family was at the time William. So William, as a person, had two sovereignties to some extent. He was the sovereign of Netherlands, and he was the sovereign of Luxembourg. And he decided in 1815 to merge Netherlands and Luxembourg, to include all those provinces in one state. And he could decide so because he was the owner of Luxembourg. He could say, well, I don't make out of Luxembourg a state, I just make it a province. So if he was the owner of Luxembourg, he could decide to merge it with Netherlands, and he could also decide to split once more Netherlands and Luxembourg. And he could do it in the name of international law, an explicit provision of the Treaty of Vienna, which says that he is the sovereign about Luxembourg. So, and therefore he can use this international norm in order to get rid of the Belgian constitution, to tell the Luxembourg people, you are not allowed to obey the Belgian state because according to international law, you are my subjects. And here you see direct effect of international law. So he makes out of the Treaty of Vienna a direct international, a self-executing international law. And he uses international law to get rid of the Dutch constitution. He cannot be accused of infringing the Dutch constitution by taking Luxembourg out of the state of Netherlands. And he uses international law in order to create the new Luxembourgish state, the new constitution, the first constitution, this document of 31st December 1830. And he uses international law as the legal basis of his competence to create a state and to create constitution. So the Constitution of Luxembourg, the first Constitution of Luxembourg, is based on international law. It is valid because it is linked to international law. And that is what Kelsen will later say. What is international monism with primacy of international law? It means roughly that all the national legal systems do not have an independent Grundnorm, fundamental norm. The validity of the national legal system is grounded in the international legal system. And the international legal system is grounded based on the hypothesis of the Grundnorm, the fundamental norm, which says international law is valid. So, what Kelsen will say later has already been implemented in Luxembourg in 1830, 1831. Now, this idea of monism did not come out of the blue sky, because this type of monism has not been invented by Kelsen, Verdroß, Kunz. This paradigm goes back at least to Grotius, to the school of Salamanca. The idea of the civitas maxima, the idea of the universal legal system of the Catholic Church, which is above the empire is above the national monarchies, and so on. And those old ideas of Salamanca, Grotius, were more or less maintained in Netherlands, and the first Grand Duke of Luxembourg was Dutch. It was William. William was a Dutch, so he was immersed in this Dutch legal context. So the monism traveled from the Netherlands to Luxembourg. It's a legacy from the Netherlands to Luxembourg. And interestingly, and I will stop here, this legacy was implemented in Luxembourg in 1830-31, not due to some ideas of peace. That's the idea of Kelsen. Kelsen says, very briefly, he says, what is the ideological ground, the basis of monism with primacy of international law? He says, well, it's very easy. Primacy of national law is based ideologically on the idea of nationalism. Monism with primacy of international law is the legal expression of the ideal of universalism, of universal peace. But if we come back to Luxembourg, the argument of William was not peace. He was not proposing peace to Luxembourg, to the Belgians, and to the Dutch. He was just saying, this is the law. This is international law. And why did he use the theory of monism, primacy of international law? because this theory served his interest, his own interest. It was useful for him. And he tried to convince the Luxembourgers that it would also be useful for them. Monism is something useful for you, Luxembourgers. Why? Because, as I told you, you will get your own state, you will be independent, you will have your own tax law, paying less taxes, you will get your own parliament, you will, lots of advantages. So, and that is my final conclusion. If we think about dualism, monism, the primacy of international law, monism, primacy of the constitution, these are theories. And we can know where the theories come from. We can situate them in the history of ideas. But the crucial question is not the ideas, it's the question, and there are many theories about how to articulate international and internal law. Who decided when, for what reasons, in what context, that we, the state, the system, should use either dualism, monism, this monism, or another monism? And the case of Luxembourg shows that dualism in 1831 would not be useful at all. And monism with primacy of national law, of the national constitution, would not be useful at all for William. The only theory which in that context was useful was monism with primacy of international law. And the second question then, which follows, is why did Luxembourg later, with different political actors, under different circumstances, why did Luxembourg maintain this paradigm of monism? Why didn't we in Luxembourg switch to dualism or to monism as primacy of national law? And historically, during 19th century, the monarchs in Luxembourg always defended monism with primacy of international law because it served their own interest. The power of the Grand Duke in Luxembourg was ultimately based in international law. And the constitutional law in Luxembourg very often tried to limit the power of the Grand Duke. So a very useful tool for the Grand Dukes in order to stop or to block constitutional norms was to use international norms against revolutionary constitutionalism, against constitutional amendments. And they use it all the time, and it worked all the time. And why did Luxembourg continue in 20th and 21st century to maintain monism? Because now monarchy isn't anymore a power. It's the Grand Duke has no power anymore, except, some exceptions. But why did Luxembourg maintain? Because it's a small state. And a small state, international law is useful for small states because international law now in 20th century and 21st century protects the sovereignty of countries against potential superpowers who potentially are maybe interested in invading you. Like, well, we have examples. So international law is useful for small countries in order to maintain their independence. It's not their army who will defend national independence. It's the law, and not constitutional law. It's international. It's a weak argument. It's the only argument you have. And so you need to say international law should prevail, even above your constitution of the superpower. So you have to defend monism. But, and that will really be the last word I say, currently Luxembourg is part of the European Union. And the European Union is not a small state. The European Union is not always favorable to international law. And the European Union is not favorable to monism. That's the Cardi case. The European Court of Justice of the European Union, in the famous Cardi case. Cardi is a problem where the United Nations, in the context of a fight against terrorism, the Security Council establishes a list of people accused of being terrorists. The list of those people cannot, in the system of the UN system, cannot be contested in any court. There is no UN court who can make judicial review of this list. This is a problem, a rule of law problem. The United Nations require all the national states to implement those measures against terrorists. And one of the persons who was on those lists was Mr. Cardi, and he said he's innocent. There was a mistake made. And he could prove it. He is not a terrorist. And the European Union, in the first step, implemented that list. So they blocked all the banking accounts of Mr. Cardi. So Mr. Cardi, of course, took some very good lawyers. And he went, because it's a European Union decision to block, to implement the sanction of the United Nations. So he went to the European Court in Luxembourg, and he won his case. And in the famous Cardi case, the European Court said that in the European Union legal system, what is the top? What is at the apex of the European Union system? It's not universal international law. It's the treaties of the European Union, which contain the Charter of Human Rights, and therefore human rights prevail over the European Union measure to implement the UN sanctions. Therefore, the European Court should exercise judicial review and check whether Mr. Cardi is innocent or not. And they considered that he was innocent, and that therefore the rights of the European Union Charter should prevail over the regulation of the Commission or the Council, which implemented the sanctions. And interestingly, the decision is a little bit ambiguous about, and what about international law? About universal international law? And it kind of sets aside the UN law. And some people consider that the European Court is implementing kind of dualism, and some consider that it is a kind of monism with primacy of the European Constitution. We're still not, we're not clear about it, but it's definitely in CARE, it's not monism with primacy of international law. And therefore, as Luxembourg is part of this bigger system of the European Union, I personally consider that the traditional paradigm of Luxembourg, of monism, of primacy of international law, that this paradigm is dead. It doesn't exist anymore. But most lawyers in Luxembourg are still not aware of it, because all Luxembourgish textbooks still continue to say monism, international law, tradition, and so on and so on. But as a matter of fact, I think it's that, and the new constitution of 2023 does not spell out, it does not explicitly enshrine this monism, this traditional monism of Luxembourg. It just says, roughly, we have a hierarchy of norms. There are higher norms, there are lower norms. We know the acts of parliament is beneath constitution, whereas international law, it's not mentioned in the constitution. And the constitution says the judges define and implement the hierarchy of norms, but we do not know exactly in black and white what is the hierarchy of norm with regard to international law. So I consider monism is dead due to and it has been killed in Luxembourg by the Court of Justice in the CARE case. If the CARE case is a precedent which will be followed later, that is of course the question. And interestingly, lots of government participated through this trial on CARE, but Luxembourg did not. So the Luxembourg government did not participate in this debate in the Court of Justice, in the CARE case. So Luxembourg was not present to defend monism as we understand it traditionally. So nobody defended monism in the Court of Luxembourg, and therefore I think monism will disappear in Luxembourg, and probably will also disappear in the Netherlands. They are also part of the European Union. And that means that, as far as I know, in the world, there are very few countries who implement this type of monism. And the only case of which I know, which also apparently implements monism, with international law being higher than the constitution, and maybe you have some more. It's a Latin American country. It's Suriname, as a previous colony of the Netherlands. But I don't have some clear information about Suriname, but maybe you have some connection with Suriname, so maybe you can tell me. But tradition in the European textbook, the only countries which apparently in the world implement monism with primacy of international law would be Netherlands, Belgium. That's all. Luxembourg is not mentioned, and Suriname isn't mentioned neither. So maybe there is none country in the world which would currently implement primacy of international law even above the constitution. Thanks very much for your.
Falar, só fazer uma pergunta, só um comentário rápido.
Vou passar então a palavra para o professor Reverdel.
Professor, thank you for your speech. I will introduce not a question, but a new example for your research of the royal family that can vote. We have another example here in Brazil. In 1994, the members of monarchy vote in a referendum to restore the monarchy system in Brazil in 1993. So all members of the royal family vote, expend a lot of money in a campaign to restore the monarchical system in Brazil. So we have
I remember that.
We have
provision in the
another
of Brazil, of course. Yeah.
So it's not Luxembourg, Italy, or Spain. We still have Brazil in this, this small numbers of countries that allow the king and the queen and the royal family to vote in this field. Another point that I want to mention is the head of state. It's a important thing to consider. The head of state represents all the country, not part of the country, not a party that will be elected. This is the reason most part of the people that consider the representation abroad or representate all the country, they are not allowed to vote, like Japan, the example of Japan. And I think in these questions, we need to separate the institutions and the person. Because I remember the royal family in England when the prime minister was elected, Tony Blair was elected. And I don't remember the exactly year, but when the Tony Blair was elected, the Queen Elizabeth, in that period, Princess Diana died in a crash in Paris, and most part of the thing she disagreed to do, given a speech, open funeral for her, and many procedures that she needs to follow. She disagree in all these procedures, and she made, and probably in private considers she never will give a speech for the Princess Diana, open funeral for all citizens and members of politicians, head of states of other countries, and singers and other people that participate in that period of the Queen's Elizabeth. So I think it is in this question, the most important thing is to separate the institutions and the functions of institutions and the person. The persons, we know they have are conservative or liberal or labor, or it depends. But in the institutions that they represent, in most part of these institutions, they represent the abroad and all the people considerations and ideas. So the abroad functions of the head of states is to represent all the people. This is the reason they are not allowed to vote. I agree a little bit with Japan, not system, but idea, because you have the institutions. In the institutions, you cannot be member of parliament and at the same time represents all. Member of a party and represents all. Members of sections of society and at the same time travel to sell the image of the country and sell the conventions and bring money for the country and represents all the citizens. So, or you represent parts of the citizens or all citizens. And I agree, if you are a person different than institutions, you are more conservative, Catholic, or it depends on this own conceptions and
I do agree that on this debate, you have to separate the question of the right to vote and the right to stand for election. The right to vote in elections and referendum. Because there it's a secret, it's confidential. The politics is present, of course, but it may remain totally confidential. Of course, if you stand for election and if you are elected, then you have to defend openly and in a controversial manner. You have to take politically position against other people, other parties. You are partial. And that is what we expect from politicians, to defend a certain view. The majority, if you're in the majority, well, it's legitimate to defend the ideas of the majority, not to defend the ideas of the minority. That's democracy. Now, I think that your argument is a little bit dangerous, because if you apply it, I fear that, let's take the example of the Portuguese President of the Republic, which we may agree is not supposed to do politics. It's more a representative function. Or the German President of the Federation. So these presidents in a parliamentary system, they are elected, they are mostly former politicians, so everybody knows they have political ideas, and we know which ideas. In the context of their function, they have to overcome that. They have to be more neutral. But we all know that a previous social democrat in Germany, when he becomes president, is still a social democrat. And but we expect a certain neutrality from the German president, from the Portuguese president. We would not expect neutrality from the US president. You know, neutrality is an argument for certain types of head of state, not for, I imagine you would not expect neutrality from the Brazilian president. He's elected to have a certain program, to implement a program. It's political office. It's not neutral. But for the Portuguese president, the German president, maybe the Italian president, some others, you both expect, you expect neutrality, but at the same time, you still recognize that it is a former politician. He or she has political ideas. He is allowed to have political ideas, but he should abstain to be too controversial. He can take some strong position in some speeches, like, you know, for example, if you defend solidarity, if you defend humanity towards migrants, if you defend the Geneva Conventions on asylum seekers, this is not neutral. This is very political. If you defend gender equality, sorry, that is political. It's not party politics, not exactly, but still it's political. And those presidents in Portugal, Germany can do such discourse. In Luxembourg also, the Grand Duke Henry, the Grand Duke Henry was the best defenders and supporters of the migrants, of solidarity, humanity, and so on. Most people never contested, but at some point there was one far-right party in Luxembourg said, sorry, you should stop talking all the time in favor of migrants, women, and so on and so on. This is political. Yeah, of course it's political. We know. But, you know, neutrality is, it doesn't mean, if you are 100% neutral, you just stop talking. All you do is the Queen, you present, you read the speech written by somebody else, and everybody knows it's not your speech, you're just the mouth. But then you never deliver a speech. So I would say in Portugal, Germany, the presidents have the right to vote. I don't know whether they have the right to stand for election. Of course, there we kind of see that during the campaign, it will be problematic because the same individual is already doing a campaign, a very political campaign, and at the same time should still be head of state. You would say this is, so I don't know for the rules in Germany or Portugal. I could guess that maybe if, as a head of state in such system, if you want to run for election to parliament, you have immediately to step down, and then you can run for election. But they have the right to vote. I don't know any republic where the head of state would lose the right to vote because of him being president of the republic. So the argument of neutrality can be used against the right to stand for elections, but it's never used against the right to vote in republics.
Remember the election in Portugal that Mário Soares and Cavaco Silva, head of states
and prime
ministers, and they are in opposite leftists and rightists.
They run for president or for?
They run for the president.
Okay.
And the question is, how can you combine the fact that in the past he was prime minister in a leftist, and now there is a prime minister rightist, and now you are head of state? Yeah. How can you combine this?
So that shows that in Portugal it is possible to run.
It's possible to run. And it was a very strong debate in Portugal. How to combine two visions of members of the state and members of prime minister and head of state, abroad and internal system. And I remember was a very strong discussion in Portugal. Neutral, how can you travel and defend rights and things like that when you, in the past, we know we know that you elected by a rightist or leftist party. So this is a very strong example that this problem. But in monarchy, I think the heredity, the not election is you come, it's birth. So it's different than to vote, and it's a different way, a perspective to show the same problem, because you were not in the past elect of prime minister, and after you assume the condition of head of state. So a very interesting perspective to see the same question.
I think it's, so legally speaking, we are talking about the question of how far the limit is proportional or not. And of course, where do you put, how do you evaluate, assess proportionality now? And of course, when you think about is it or is it not proportionate, you will kind of refer to experiences, historical experiences of your country. And in Luxembourg, I always refer to the example I told you when in 1945, for the first time, the royals, some royals, all the royals except the Grand Duchess were enrolled on the list of electors. The husband so had the right to vote. Nobody cared, nobody criticized that. And interestingly, he was not kind of, absent husband. He was not like, the husband of Mr. Merkel. Nobody knows the political idea of Mr. Merkel, and nobody thinks that Mr. Merkel had an influence on Ms. Merkel. But we know that husband of Charlotte was Felix, Prince Felix. Prince Felix was a previous soldier. He fought in the First World War on the side of the Austrians, bad side. So he had some strong ideas. And we know from archives and from historians that during the Second World War, when there was a decision to be made, should the Grand Duchess remain in Luxembourg, which will be occupied by the Nazis, or should she leave, go abroad to England, US, and so on? She hesitated. And the government, she wanted to go back because she was already in Portugal, and then she said, maybe I should go back to Luxembourg, because some people in Luxembourg, the officials which remained in Luxembourg, even asked her to come back. And she kind of hesitated. And the government said, no, you should not go back. And her husband also said, no, don't go back. So he had an influence, and he took some positions. And nevertheless, nobody criticized him to be elector, to vote. So in my assessment of proportionality in Luxembourg, I just give the fact, if we accepted in Luxembourg that Felix could vote being the husband of the head of state, then we should also accept that if the spouse is not the man but the wife, then the wife should also have the right to vote. But currently it's not the case. So that's not logical. And it's not proportional. So but I have that experience. I can show, historically in Luxembourg, the fact that Felix had the right to vote did not trigger a debate, was not controversial. So it's not necessary, apparently, in order to maintain the neutrality of the Grand Duke, to abolish the right to vote of the spouse, wife. But maybe the assessment could be different according to the personality of the royals which are concerned, of their historical context, and so on. In Japan, neutrality is understood in a very radical way.
Merci à vous pour votre présentation, votre exposição. Quero agradecer, então. A gente só daria uns 5 minutos, 3 minutos para o Francisco. Pode falar amanhã. Como nós vamos continuar o evento para amanhã, então a gente também queria ouvir o Francisco, então ele vai falar amanhã. Se é possível? Et demain, vous parlez? Très bien. Porque nós temos que finalizar aqui o evento no horário, a gente já passou do horário. Eu também me excedi no meu horário e hoje foi um dia, mas fiquei muito contente com todas as intervenções, inclusive do professor Reverbel, e merci à vous, professeur. O professor Luque nos trouxe, então, uma visão complementar, que foi isso que a gente combinou de eu falar antes, para explicar um pouco o que seria esse sistema, para que ele pudesse também fazer essa exposição e trazer do aspecto da União Europeia. Merci beaucoup, c'est très bien votre exposition. Então, finalizamos por hoje, aguardamos todos amanhã no auditório, como que estará presente o nosso presidente da OAB e o nosso digníssimo aqui e emérito professor, que nos honra com a sua visita. Vamos ter também o Francisco para nos dar suas considerações, e o professor Reverbel e o professor Alfredo também. Muito obrigado pela presença e aguardamos todos amanhã. Muito obrigada.
Bom.